Don't like the number.
No. This can the respondents were already listed during the manage of the instant system and only so remaining for so regarding the bank. They are following the matter of anything. Senator settle the matter also.
Let me send it to mediation.
Yes.
You want to go to mediation? It is submitted at the bar by the counsels appearing, it is submitted by the learned counsels appearing on behalf of the petition, on behalf of the parties. That nothing, that the respondent have already been reinstated. And the only issue is as regards the entitlement of the respondent to the back wages. It is also submitted that the parties would like to explore the avenue of mediation. Considering the above, this court therefore directs the registry to place the matter before the mediator to list this matter on 17th of February 2026. In the meantime, the mediator so allocated the matter would try to resolve the dispute between the parties and submit a report if possible. Contractual work for what?
So,
Contractual bills?
no bill, out of what?
Award of work, there's a stake?
No.
Then why do you want it?
Because they alone they usually awarded to the consider some other responsibilities. So we have already and they are already access.
After vacation? Before.
After when? After.
Okay, let's see. Let's see.
But an identifiable member of the supplement is where minor activity in different different form. Question I make to mention for content matters, 2020 matters. We actually next week. And
Which is in document declaration, two repetitions for withdrawal.
Tomorrow?
Yes.
Tomorrow?
Of the list, item 6 to 8.
the people of the on the map on the last page.
You are for central government. What is your submission?
After passing of the order under 7A, there was a statutory provision for 7I by state.
Huh?
There was a statutory provision under 7I for appeal. So they have.
Forget about that. Forget about that on appeal, please. The matter has been being pending from the year 2016. It doesn't look nice for this court now to send them to appeal. But the question is that they are liable to pay, there is no doubt on that. So they will be therefore directed to pay. But it is your responsibility to find out whom to be, in whose presence, in whose account you are going to deposit. Okay?
Yes, Martin.
We have considered our people's one last day. Right, this is Roy and then I have seen another. There are two other cases also in the Supreme Court which have indicated member that in such cases the benefits are not found. Just to be reminded, but then what?
Remanded is one thing.
Why not?
So therefore, what I am trying to do is,
What?
you see, there is the accruing of interest also. One has also to take note of. There is no denial that you are liable to pay, but the fact remains that whom to pay. Whom to pay, they will find it out and make the payment. And if they don't, then it will go to the coffers of the state. Isn't it? But at the end of the day, you are to pay. So your liability is duly taken care of. So that your liability is there, you have to pay. And thereafter, how they manage to give it, that is their lookout. They will it is a case of remand only. They will remand it. It is a case of remand, but you make the payment. Once you pay, the matter stops as regards your liability. How they get hold of those persons to pay, that is their lookout.
One thing, how the certain pilot that probably would consider is under the scheme, my the provision of scheme, my lord. It again passed, my lord, I use the street 33. It shall be the responsibility of the principal employer to pay both the contribution paid back by himself in respect of employees directly employed or also in respect of employees employed through contractor and also the agency. This particular provision matter has not been considered. But the liability, the conduct flexible required in terms of this.
So what the Supreme Court did, or the High Court did, they just remanded the matter. But it doesn't, because you see, whatever payment you are liable, there is an interest element. So once you pay that amount, interest ceases. And making it remanded out there, then they will again come up with this thing. Makes no sense. Let them take the exercise.
Post deposit.
Huh?
Post deposit, we deposit the amount. Then post deposit, they carry out the further.
Whatever exercise they carry out, they will carry out the exercise for giving it. How they do it, that is their lookout. Because you have already given the details.
But the contractors have.
You have already given the details. So the only question therefore is how they make the payment. They will conduct an inquiry in terms of 7I or not 7A or 7I. 7A. So let them conduct the inquiry as per 7A and may also call you, but your responsibility ends with your deposit. All the 3 writ petitions, why 3 writ petitions?
Because the separate assessment orders, my lord.
Separate orders. Give me the dates of the assessment order.
Petition by lord.
2016 one.
2016, the order is my lord 36, 2016.
Huh?
7853 of 2016, my lord. The assessment order is of 36, 2016.
36, 2016. How much is the amount?
The amount is 1,87,740.
80?
187,743. Second petition, the lord. Of 2022, sorry, 2717 of 2020. The assessment order is of 16/12/2019. And Excel 32.
The amount?
The amount is, my lord, 29,177.
The third one?
The third, my lord, the 119 of 21, the assessment order is of 17/9/2020. And Excel 12, amount is, my lord, 10 lakhs, 6,976.
So these are the three.
Right.
Let us now 7, 8, type 3. Let us see the impugn order.
Page 84. Page 84. Annex 25.
This is for the period from 11, 2020, 2000, na? To 8, 2005.
Period, my lord, this was immediately after creation of BSNL from the POP. So a lot of records, my lord. Could not be traced from that.
Anyway, you have given the details. Now, kindly come to page 90. That this order is without prejudice to further inquiry, action taken or to be taken, or reopening of the cases by the department under 7C or so and so. So. What are these provisions for?
ABCR.
This is under this act, no? 52.
Fourteen is for my lord, panel meters.
This is for escape assessment.
Yes, assessment already has been done. But then they said that if any further escalation.
So this is under done under 7A.
Okay, yes, 17%. We have, we submitted the.
Hmm?
In all three cases, 7A notice was issued to us. We have here, that we only have the list of the contractors. But then
List of the,
Contractors, my lord, who have worked during both.
so you had the list of the contractors, but you didn't
We
have
don't
the,
have the list of laborers engaged, my lord, by the contract.
you don't have the list. You only have the list of the contractors.
We say that we can get it from the contractor, my lord.
So how did they make the assessment of 1,87,000?
Yes, my lord, from the fact that we have given the bill component of the contractors. And
Where,
bill component,
no,
my lord, we have
in
taken out of
the impugned order, where is it mentioned?
In project comes page 46 first. Details of the calculation is not there in the
Page 40.
order.
Page 40.
Yeah, page 89. Submitted by the contractors to the establishment wherein surprisingly the same and common declaration has been found to have been incorporated in each bill so submitted. That dash numbers of laborers are engaged in the aforesaid work and the work of the human is so EPF is not applicable. Being the employee satisfied himself and absolved in the certificate by obtaining the certificate, else I have also seen the establishment and direct money to the funds. Directions given by
That to be portfolio that pays 40 and 41, where we had sufficient minority raises component. And change it.
Yeah, page 89. They say, as regards the aspect of identity of the workers or the beneficiary, I have satisfied myself with the submission made in the form of inspection reports by the departmental representatives, wherein 269 workers were identified, engaged by or through 16 contractors with the number of days worked, rate of wages earned every day, and the amount of wages earned by each such worker. Now, so they have the details.
So we might not. It's a number of workers. The names are not available, but this number has come from my case 40.
So they will identify now to whom to
For the
deposit.
contractor, they can identify. For the contractor, they can
To
identify.
the contractor, we can identify, because they have a list of all the contractors. In page 40, gives the details.
Page
40.
This is furnished by us only. Is that these are the wages component, these are the contractors and these are the wage components. So therefore, this should be the year sheet. But this is our calculation only, that 187,740. Here, due, that we my lot. Yes, yes.
So they have it. So they will identify it. Now, heard Mr. B. Pathak, the learned counsel, appearing on behalf of the petitioner. Mr.
That's not,
As thus,
not, managed,
thus
not any.
appears on behalf of the respondent numbers 1, 2, and 3. Gusto. In the three writ petitions, in the batch of three writ petitions before this court, the petitioner have essayed the orders of assessment carried out under section 7, capital A of the Employees Provident Fund and Miscellaneous Provisions Act 1952, for short, the Act of 1952. The sole ground on which the petitioner assails the assessment, the respective assessment orders, is that without identification of the beneficiaries, the respondent authorities would not have carried out the assessment in terms with section 7A of the Act of 1952. So, taking into account that the issues involved in all the three writ petitions are common, this court takes up the three writ petitions for disposal by this common order, judgment and order. The petitioner, now heading WPC number 7853/2016. In the present, in the instant petition, the petitioner have essayed the order dated 30/6/2016, passed by the Assistant Provident Fund Commissioner, in exercise of powers under Section 7A of the Act of 1952, whereby the petitioner, however, whereby an amount of rupees 1,87,743 was determined to be the dues payable by the petitioner in respect of the workers engaged by or through contractors by the petitioners. Heading in WPC number so and so, the petitioner have assailed the order dated so and so. In WPC number 2717/2020, the petitioner have assailed the order dated 16/12/2019 passed by the Assistant Provident Fund Commissioner in exercise of the powers under Section 7A of the Act of 1952, thereby determining that the petitioner is liable to pay an amount of rupees 29,177 in respect of workers engaged by or through the contractors. In WPC number 1198/2021, the petitioner said that order dated 17/9/2020 by the Assistant Provident Fund, whereby evaluated amount is 10,46,970. The materials on record, as well as a perusal of the impugned orders in the 3 writ petitions, clearly show that the petitioners, through certain contractors, the names of whom the petitioners disclosed before the respondent authorities, engaged various workers the names of the contractors and the amounts which were paid to the contractors have also been brought on record by the petitioners themselves. In the present writ petition, the names of the contractors and the details of the payments so made admittedly is available with the respondent authorities, as will be seen from the materials on record. The question which have been urged by the petitioners in the batch of writ petitions is that without identifying the beneficiaries, the petitioners cannot be burdened with an assessment carried out under Section 7A of the Act of 1952. Where is that rule?
Right, and it's
You were referring to some rule, na?
exactly the circular.
Huh?
It's 31 in the first page.
No. Where is that? You were referring to some rule out here.
Or that the full matter, the scheme, rule 31. Payment of contributions. The key fact, the rule 31. Responsibility of the principal employer is what company by himself in respect of employees directly employed. And also in respect of employees employed through or through a contractor. Also a basic example.
The answer to the dispute raised in the present petitions can be seen from para 30 of the Employees Provident Fund Scheme 1952. Whereby a responsibility obligation have been casted upon the principal employer to pay both the contribution payable by himself in respect to the employees directly employed by him, and also in respect to employees employed by or through a contractor, and also administrative charges. Paragraph 30 of the said scheme of 1952 being relevant is reproduced hereinunder. Page 87. This court further finds it relevant to take note of Section 7A of the Act of 1952, which empowers the Central Provident Fund Commissioner, any additional Central Provident Fund Commissioner, any Deputy Provident Fund Commissioner, any Regional Provident Fund Commissioner, or any Assistant Provident Fund Commissioner to determine the amount due from any employer under any provisions of the Act of 1952, the scheme of 1952, or the pension scheme or the insurance scheme, as the case may be. It is further seen from subsection 2 of Section 7A that the officials mention the designation of which the designated officials, as stipulated in subsection 1 of Section 7A of the Act of 1952, have been endowed with the power to conduct inquiry. And in that regard, powers of the civil court, powers vested upon a court under the Code of Civil Procedure 1908 for trying the suit, have been conferred. It includes such powers such as enforcing the attendance of any person or examining him on oath, requiring the discovery and production of documents, receiving evidence on affidavit, issuing commissions for examination of witnesses, as well as any such inquiry and issuing commissions for examination of inquiry of witnesses. It is the opinion of this court that on the basis of the said power under section 7A bracket 2 of the Act of 1952, the Assistant Provident Fund Commissioner, the respondent authorities have been conferred with the power to ascertain who are the beneficiaries, taking into account that the names of the contractors are available as have been furnished by the petitioners. First, taking into account the above aspects, it is therefore the opinion of this court that the assailing, that the impugned order, that the grounds on which the impugned orders have been assailed do not have no merit. Inasmuch as the petitioners, in view of paragraph 30 of the scheme of 1952, as quoted herein above, are liable to make the payments as have been determined in terms with section 7A as has been determined by the impugned orders. It is the further opinion of this court that the respondent authorities, upon such, it is the opinion of this court that the petitioners therefore, it is the opinion of this court that appropriate directions therefore should be passed, thereby granting liberty to the petitioner to deposit the said amount within a time frame, and further directing the respondent authorities to identify the beneficiaries so that the deposits so made by the petitioner are received by the beneficiaries. Accordingly, the free writ petition stands disposed of with the following observations and directions. The challenge to the order dated 30/6/2016 in WPC number 7853/2016 do not call for any interference. Number two, the challenge to the order dated 16/12/2019 in WPC number 2717/2020 do not call for any interference. Number three, the challenge to the order dated 17/9/2020 in WPC number 1198/2020 do not call for any interference. 21, The petition number 4. The petitioners herein are directed to deposit the said amounts as determined in the impugned orders challenged in the instant 3 writ petitions within a period of 2 months. 2 months from the date of the present judgment. Number 3 and 5. The respondent authorities, more particularly the respondent authorities, and more particularly the respondent number 2 and 3, shall, upon deposit of the said amounts within the time as mentioned herein above, shall carry out necessary exercise in terms with section 7A of the Act of 1952 to identify the beneficiaries, and thereupon see to it that the said amounts which have been deposited by the petitioner is received by the said beneficiaries. And make an attempt, because it is very old, and shall make an attempt to identify the so and so, and upon identification to make the payment to the beneficiary. In time order so far, the latest translation.
or admission item B.
Ọসমীয়া খবৰ. What has happened? Anything?
Lordship, there's a mediation fee.
Okay. Let us argue.
Pending in the jail file of 1
I for what?
I for your person under 17 euros. For I don't take the copy of your lordship. Besides the letter, I will not.
Whatever day I argue. On that day only I wanted to dismiss it. That is why he's not pressing the I. I gave you a chance for mediation, that's all. Argue now.
This case, I am being led by health money. We, you can personally legal it and will do it. You recommend Friday.
Okay, 50,000 cost. 50,000 cost.
Tomorrow,
Okay, 50,000 cost. The money won't come to me. I'm not here. It will be distributed amongst all other councils. Really? Mr. Bhattakur? Okay, 50,000 cost.
any day, or next.
Any day, whenever you want, 50,000 cost. Argue.
Yeah, additional episode, that's why we, the last week. The expert in particular will go. The establishment.
Where's the additional affidavit? The additional affidavit file goes in. When? When did you file it?
Last week.
No affidavit has been filed. Hello? You take that ground in your division bench. Without considering the affidavit, he has dismissed. Now argue on the main thing.
As per the, Monday White Board, the establishment.
Yes, this year nothing is going to happen after being
The
dismissed.
establishment has covered heavy losses for the last consecutive year. Still they exempted from the payment of any evidence. So I connect the benefit as well as the professional loss statement.
No, did you take those grounds before the tribunal?
No,
Then you can't raise all these grounds. Don't come up with all these silly excuses, silly arguments. Yes, Mr. Bhattakur, you argue.
Lordship,
Petitioner case dismissed.
my case is concerned, your lordship, can
What?
come to page.
What happened? What are the facts involved?
The petitioners, your lordship, in fact, your lordship, they were.
In
appointed as-
retrenchment of 8 numbers, so they retrenched these people.
Lord,
So what is your problem?
so your lordship, that was not as per the, your lordship.
25B F.
Yes, no. And your lordship, the petitioner issued nothing, your lordship. Your lordship, you kindly see the petitioners, the here, your lordship, 18 numbers. They were appointed, your lordship, from 2005 to in between 2011, and various tests, your lordship will get it at page 41, your lordship.
25.
41, your lordship.
Yeah,
that is the
so
case,
11, 6, 6, 6, 6, 6.
your lordship.
Then
Then your lordship, they were.
retrenched from
somewhat-
service in an arbitrary and unjustified along with that. No, nothing is given.
Nothing.
And is he enjoying a stay?
Lordship, yes, your lordship.
Oh, we vacate the stay.
They are only pointed this, your lordship. Which they have raised, your lordship. Para 26 is their case.
Oh,
Of their case, of the judgment, page 48.
From the evidence of all workmen witnessed, it is found that management had retrenched them from their service on air without giving any prior notice. But to prove the fact, none of the witnesses have produced any relevant document. Retrenchment sorry is an order passed by the management and before that issuance is notice, yeah, but no documents. So,
Lordship, that is their, that's why your lordship. they are
matter
saying
over.
These
My
my
lordship, they want to, they fail to prove that they have been trained.
Okay, that means you have, no. So the question is, if they have not been retrenched, you are paying them the salaries.
We're being paying the gratitude amount, areas, by the binding way of installment.
No. Are you paying them the salaries?
No,
Why?
as of now, we've not been paying, but we've, they've voluntarily.
Is it your stand that you have not retrenched?
Yes, they have voluntarily resigned. It is our case, is that they have voluntarily resigned from the organization.
So voluntarily resign. That's your case. Where is your stand? Let us see your.
And they failed to put in the tribunal. In para 29 of the judgment, that is at 28 and 29 of page number 40. Workmen have failed to put the degree of retrenchment that required under the law and made for them.
What are these persons doing now? Your person-
Except one your lordship, others are not paid there. Except one your lordship, others are not paid there.
As far as my knowledge, I have been working. For that, I have to take instruction.
No. What are, where is he working? Except the one,
One petitioner is working in the media house.
which media house?
The name not there, but maybe I also we have made this clear that he is faithfully upward, therefore we are not taking taking daily hundreds of 17 years.
Now,
Rest are not your.
if a person is working, isn't it required that there has to be an intimation that I voluntarily resigned?
Yes, your lordship. Your lordship, they have, your lordship, if your lordship comes to their WS, your lordship, before they learn and patronage, your lordship, where they have said, your lordship. Please, of the department. The opposite party stated in their written section that they were from.
Wait. Just explain on behalf of.
Resign from their job. So the opposite party issued notices against them, but they refused to listen. Then verbally to the opposite party, then they did not want.
Stated in their written statement at the Labour Commissioner that the opposite party did not terminate, they have voluntarily resigned, though the opposite party issued notice against them, but they refused to receive a kind of one in the level commission. They admitted that they have received the entire salary they pay. The opposite party denied that they have not received all the facilities. Sure. That's one of them. Okay. Now, if a person resigns, because admittedly it is seen that till 2021 they were there, meaning thereby some have already put in 20 years, some have put in, the list would be around 14, 15 years. How do you compute the gratuity? Because a person is entitled to certain benefits. A person who has been who resigns, you take certain steps for once he is resigned. You must have put it in some way that they have resigned. Have you produced any documents in that regard?
So after resigning, they have been receiving the gratitude amount benefits for 10 months. Thereafter, they filed this, without any protest, they have been receiving the gratitude amount and the shares.
Where have you mentioned?
That have been,
In your affidavit, in your written statement?
my read have mentioned.
Written statement, where have you mentioned?
The instructor, they say that they need time to pay the gratuity amount.
In my paragraph 5 or 2, page 5. My read.
Where? The complainant is not properly represented, signed, verified. That is in paragraph 5. Don't come and say all these things in the writ petition. I'm not going to look into those in the writ petition. I'm going to see from the records. Let us see his evidence. All resigned on the same day, 30/11/2020. Amongst them are these persons there in who are the respondent, Lakhikanta Bormon and Susanto Soha?
Process, they are not, if they are not the partner. Even if the tribunal or
Here also he has not mentioned. What you have enclosed? Nothing. Exhibit 2 is the written statement. Exhibit 3 to 10 are the gratuity calculations. Is letter of Lakhikanta, Susanto Saha. 13 is the details of payment. Let us see exhibit 13. They resigned as per you
Yes,
on 30/11/2020. Okay. The first deposit of gratuity is made in the year on 5/8/2021. Why? Why? Second deposit in the October 2021. Third is January 2022. Why? What is this 10 months business? And you have not paid it to them. Whom have you paid? These are cash payments. Can gratuity be paid by cash?
by cash and by way of transfer to bank account also.
No, all are mostly all these three, Bolin Das, Pormes Das, Narayan Das, and Dharma Patha have been all paid by cash. See Exhibit 13. Where have you intimated them? By which letter? You have not proved anything.
Yes, when they have failed to prove for this lot,
What?
that they have resigned, that we have retrenched from it. In this judgment also,
Retrench. Who can retrench somebody? Tell me. You keep somebody in your payroll at home. Okay? That person does not come one day, it's a different aspect. Can he prove that you have thrown him out? It is your burden to prove that I am not thrown him out. Because he is otherwise in your employment. Can he prove that I have been retrenched? It is for you to prove. Isn't that the burden? That is the mistake committed by the labor court. Isn't it, Mr. Bhattakur? Is it ever heard of? That they are going to prove that they have been retrenched. How will they prove? If they have not been able to prove that they have been retrenched, it therefore makes it very clear that there is no retrenchment.
and after
You are to prove that look here,
they have been.
I have retrenched them and by making due payment of the dues.
But after for 10 long months, they have been receiving paid yet without any protest.
You are paid by cash. Where is the
But
receipt?
they haven't denied also.
Where is the receipt?
That I have to take it from them.
Where will they deny? In your written statement, have you taken the plea? No. In your evidence on affidavit, you have taken the plea. I think this is a case for dismissal with cost.
That-
Heavy cost. Maybe 1 lakh to each person.
One more day.
1 lakh. Not a. Now this person, Sunil Kumar Singh says in his cross, it is a fact that 8 retrenched workers, the salaries of the 8 retrenched workers till December 2020 were cleared in the month of May 2021. Therefore, you see that payment. No permission was obtained from the Iman so and so. Our management is not paying salaries to our staff as per Majithia Waste Board recommendation. I have no knowledge of if any criminal case is pending in the court of so and so. It is a fact that we did not pay bonus as per the bonus act. It is a fact that we did not pay leave encashment to the so and so as we so and so. Except worker, this means other 7 retrenched workers were paid in total rupees 15,000 each in 3 installments. It is a fact that at the time of termination, leaving of the services, we did not pay 3 months of advance salary. See, in my evidence, I have not submitted any copy of receipts made to 8. Look here. See, you have not, first of all, you could not have reduced that evidence, as you have not taken that stand in your written statement. The case of dismissal with cost. 1 lakh to each of the persons. Before the year, during conciliation and before the tribunal in the present, it is a fact that we have not raised any objections about the competence of Maria Union to represent so and so. We have also not raised the objection to the fact that 8 retrenched workers of this case are members of so and so. It is not a fact that the management had terminated the 8 retrenched workers of AI. I have no knowledge if they, after leaving the service by 8 so and so, they received any compensation from the year. It is not a fact that I have falsely deposed that they voluntarily resigned. I have not submitted any document of notice to the 8 so and so. I have no knowledge if before termination, leaving the job, so even any permission was obtained from the government. Our so and so Iman. So they are entitled not only to be there, they have to also back wages from 2021. Now, therefore, you are trying to save yourself with a paltry amount of some 6 lakhs, 7 lakhs, by not entering into a mediation. Now you pay more. Whether to be honest. With these facts, with these materials, very bad.
So there will take instruction that they've been working on the other account also, when after then.
So what? They will resign and again join you.
Once you even will take.
No, till the award was passed, you are to pay the back wages. What is the offer they are giving to you in the mediation?
They have only said that they will pay us the gratuity.
Ah, no.
That is the only
How much is the gratuity? Some 1 lakh or something.
lot.
How many persons are there?
8 or not.
8. Pay 3 lakhs each. You can have it. Some mediation. 3 lakhs each. 1 lakh is the gratuity and the other 2 lakhs. Then also you save.
But my farm is running in losses.
No. Ohame Khobor. Ohame Khobor is doing well.
No, sir, I have managed the balance sheet also for the last 5 years. It's going on losses.
What is the ranking out there of your newspaper?
I don't know, sir, I have taken instruction.
After Pratidin comes your newspaper.
But
After Pratidin, your newspaper comes.
we have been running, I have managed the balance sheet also for the last 5 years.
So you have machines. Okay, sell those machines and pay. Sell off those machines.
You have to pay lot, you will enter, endanger the other employment of other employees also.
What?
Will endanger the employees of, we have been, 80 number of employees are there presently. It will endanger the other livelihood of the that employees also.
So what? For that again you pay a further amount. So the best option is, how much do you want? How much do you want?
Then it's up to them.
Huh?
We only wanted the back wages.
How much is the back wages?
What has come from your lordship, about this 3 lakhs or probably they will be satisfied with that.
How much?
That amount has not been mentioned here.
Anyways, for 3 years, if they are putting their last drawn salary in the gratuity as 11,000, no, let us take 11,000.
1,500 euros.
First of all, they have paid as 11,000, which also could not have been done, taking into account the minimum wages. As per section 5 notification, a person working has to get something more than 600 or 700, which comes to around 18,000. We impose that also. 18,000 into 3, 12. Into 3, how much? 4. You want to Yes. Take out your mobile and calculate 18,000 into 3 into 12. Into 12. 18,000 into 12. Into 4. Into 5. 1, 2, 3, 4. 4. 21, episode 22, 23, 24, 25. 5 years into 5.
It's comes around 10 lakh 50,000.
See, per person. Into 8 is 80 lakhs. I am asking you 24. Then, pay 24, get out of this.
The project, one day will be given, we'll take instruction, then we'll.
Tomorrow, 2 o'clock. Pay the 24 lakhs, we can do it. Otherwise, nothing to it. We dismiss it. I have not made, I don't have a CAV, so I can make it CAV and then dismiss it with cost. The matter having been heard, now we'll take it up on Thursday at the item number 1.
On Friday, maybe Friday. Friday.
Friday I will go.
Friday, why?
will be.
Why Friday? What is it? Friday is so good?
Friday, my senior will come.
Ask him to appear out here if he has any problem with the video conferencing. And tell Mr. Bonik that in all other matters till next week, his matter, none of the matters will be taken up if he is not appearing on Thursday in this matter. All matters will be adjourned. Having heard the matter at length, list this matter on Thursday at 10:30 a.m. as the first item.
For hearing item 5 for third.
Yes. Where is Miss Egael? What happened?
I think they are just taking time matter one. Since last 1 year, from this or that, the matter.
No. What did I ask you to do last time?
Pata is there already there, the details of the land, the duties on record. But should we kindly take the affidavit which was filed on 20.
What is that land? What is the boundaries?
Well, those boundaries, we could not get from here.
No, Mr. Counsel. Last time, didn't I tell you how to ascertain the boundaries?
Well, we thought that because the sale my lord, we thought ascertain the sale. The sale we have sold my lord, we thought ascertain those sales. Because the option had pointed out that we had Damabandi, the rates of land which is written, that doesn't come down if we totally, it doesn't come down to 50. So the Pata is already there, because we have filed. With the Pata, the details of the lands are there. At page 77.
So therefore, the question would be like this. You, along with your persons whom you have sold, will be the owner of the entire Dagnam fire as it existed then.
We have sold my lord. So this is the tag, the.
What is this?
Like 56, 83, 85, 86, are the debt which we have sold.
No, understood. So you see, originally that you are the owner of duct number 5.
Right.
From there was a partition case
Then these tags.
whereby 8 ducts came into existence, isn't it?
Yeah.
Out of these 8 ducts, some of the ducts, some portions of the ducts, or some ducts or portions of the ducts have been sold by you. So the remaining land is yours.
Out of the original tag number 5, these tags were cut, that is where. Fifteen tags. So original tag number 5, there was the entire land, then subsequently this tag number 5 was partitioned and these different tags were created. Then tag number 5 only one figure took up 15 acres of land were retained and other land were different tags were allocated. 44, 45, 46, 50, 51, so out of these tag numbers 55, 56, 83, 89 and 86 has been sold. And the Pata EPF, the government record 5 years and affidavit melon, filed on 29/7 at running page 77, the Pata is there. The total land which is given in the Pata comes to my doctor.
You see, Mr. I fail to understand, make you understand what I was trying to do. Mr. Henry, kindly see. Duct number 5 was the original duct. There is no quarrel. The duct number 5 belonged to them. Out of the duct number 5, 8 or 9 ducts came into existence. As would be seen from the materials, as I could see it on the last occasion. From these 8, 9 sale deeds, I therefore asked him that if you will definitely have the schedule to those sale deeds, which he is not in a position to help it. So this court cannot go further to help him out, be that as it may. So whom he has sold the land, along with the Patada, will be the owner of the land of duct number 5 as it stood earlier. And you have the schedule in respect of the duct number 5 as it stood earlier. There's no quarrel with that. Your problem is you don't have a Patana, it's Patana, yes, the duct number 5. The problem which is being faced is that you don't have the smaller ducts. There's no survey being carried out in respect to the smaller ducts. And as such, you are not in a position to find out exactly what has happened. But be that as it may, duct number 5 as it is already there. So why don't you carry out a demarcation calling all the persons whom he has sold as is available in that particular Jamabandi and ask them notice. And then on the basis of that, you carry out the demarcation. Then you get the entire duct. This is the thing which he should have given an advice, but it is for this court to give all this type of advice. This is what is the problem which is happening.
So these persons were they are not resident of India.
You have a legal counsel out there who goes out there. He doesn't explain him in this manner, whoever it was.
I don't have any idea about the identity of the property.
He doesn't have. So therefore, the question is, one thing is very admitted. That is, you know what is duct number 5 as it originally is. There's no quarrel with that. So therefore, when you call up all the other persons whom in the Jamabandi it is seen that there has been certain sales being made, they will be in a position to identify, ask them for their sale leads. Because they have sold it, but it is for this court now to find it out. They have sold this in with certain boundaries or without certain boundaries. But they have sold it, so their names therefore appear. When their names appear, all these people. And then you can ascertain which is the area. But the fact remains overall that they are in possession of dark number 5 as it originally stood. Now, it is the question as to whether they were in part of their land or somebody else. Maybe in some part of the petitioner and somewhere. But the fact remains that they are in possession of a land which does not belong to the CRPF. There's no quarrel with that proposition.
Then this is trace map, when we try to get a trace map, we are not even what matter is applicable, because from the trace map, there will be different dark square. Now, the case of the respondent state is that they could not identify that number 5. Now, let us leave that. So,
Counsel,
we have
no,
shown
no,
by-
no, 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 no. Their case is not that. They don't identify dark number 5 as it originally stood.
No, they say that the Venn map, they could not identify.
No, 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 no. They have the original dark number 5, isn't it?
No,
They have it.
no,
Now, from this dark number 5, you have these 9 darks.
Now they say now this is the Jamabandi manual. In the Jamabandi, this dark 49 and all these dark numbers are there. So in the affidavit, they say in dark number 5 originally as it stood by, say 50 weeks. Then in the Jamabandi, how could they find this dark number 49 contain this much of land? They does not dispute that.
No, no, no. That is not a problem. No, no. That is not a problem. Because when you partition out,
Yes, but
when you partition out a particular dark number from the original dark number, you will give certain area. So therefore, they know that dark number 49 contains 2 bighas or 1 bigha, what is it? But the only thing is, they have not put it in the survey map, which they have not done. But why are you not understanding, Mr. Das, that what is your exercise you should carry out?
but these methods, these are old, these methods, it's not.
First of all, you have approached this court after 1977.
No, no, we have
The
told
problem
you-
arises because of that.
No, no, we have
No, yes, they are settled out there from 1977. You have approached this court late.
told-
It's a different thing that this court have been pursuing this. But if, no, Mr. Das, if you are not in a position to help this court, I'm not going to help you out. Last time I gave you an idea for this court, it is not for this court to do it. Okay. Taking into account that there is no help, this court is not taking into account that the matter cannot be resolved in this manner. This court, it is seen that the respondent, circle officer, have issued a communication to Mr. J. Hendrick, the learned junior government advocate, dated 2011-2025, wherein it is mentioned that there is a requirement of carrying out a complete demarcation of the land parcel in a transparent manner in presence of the original pattadas of the legal heirs and the required departmental officials. The said instruction is kept on record and marked with the letter G. Taking into account that it would take some time, this is the matter of the 3 months, taking into account that the matter would take some, this court releases it from court.
There, no, time may be. Because they are well,
No,
years, 89 years.
I'm not going to, because you are not helping this court. No, no, Mr. Das, you are not helping out this. It is not for this court. Okay, listen. List list the matter before any other bench.
They are the custodian, because they are asking us to show the land.
I'm not going to look at it.
I'm okay. Item 9 and 10, but,
This is the matter before any other bench. Release from. What is this?
It would have to say the name of the bus whether in the companion.
His case is bad. Your case was good.
Like, there are two issues in the reference. One was that my lord, whether this voters, six voters should be regularized.
Huh?
And whether these six voters should be regularized. And secondly, my lord, whether they be entitled to bonus. So as far as bonus is concerned, my lord, the tribunal saying that we are entitled. It is that, my lord, their petition has been filed. And the case for regularization was. my
The
lord,
bonus days, you are entitled, there is no quarrel with that, that is his case. But the question of regularization, the court, the tribunal did not. So therefore you have come before us. Yes, Mr. Singh, what do you say about the bonus?
Case has taken my lord in view of Dharam Singh, sir.
Huh?
Dharam Singh's husband and Jagbir's husband, my lord, now doing some, I was saying that we have been working continuous for last 25, 30 years. It cannot be called casual labor. So therefore, your husband's, my lord, has to be considered.
But can the court direct regularization?
Vinod Kumar should go and Dharam Singh, such direction, certain power. Year round of petition, my lord, that also come up. We came before this court. The court said that in your Umar Devi 2015, the court said that we cannot pass any positive direction. But then however, your remedy is left open to the, before the industrial right. So therefore, the reference was.
Did it say that remedies lies before the industrial tribunal? In which case?
There was a petition earlier of 2015. That was be available in our explanation, I think 2092.
Page?
WBC number 2429.
Which judgment you are referring?
Rendered in the petition balance.
In whose petition?
By the
Huh? Okay. This will have it later on. Mr. Pathak's case, we'll have it later. You argue your case, this will segregate. We dismiss his case, let him get ready with his.
I was.
No, forget it. No, sorry.
Page 60.
No, I'm not going to take up that.
He will have to.
Sorry. Okay, argue on these things. We only regularization of air and formers. This aspect regularization will be decided later by another bench.
Page 64. I was referring
No,
to
sorry,
page
don't argue.
209.
You argue.
That we are not entitled for bonus because bonus is not there in the food corporation. Bonus is not there in the food corporation of India. Incentive is there for the workers, man. If they work overtime, then they are entitled for incentives.
Record size,
They were it is only on need basis for collecting the goods.
They are different aspects. One is bonus is not there in FCI is one thing. Are you arguing that point? Or they were engaged in as casual labor? Which is work?
In my case, we have stated that it's stated in paragraph 18 and page 13 of my big petition.
where in your written statement you have taken that you don't pay bonus?
Written statement, I don't please start from page 47.
No. Say the internal page.
Page 48, my lord, paragraph 7.
Say the internal page of your written statement.
Statement page 2.
Where is it? Where do you say that FCI does not provide bonus?
That is not.
Then don't make the several submissions. We are on a writ petition asking for a certiorari against an award passed whereby you have been directed to pay bonus. Argue it. On the basis of records, don't make unnecessary arguments.
Regarding is not stated in your written statement.
What is your stand? That they are not entitled to bonus? Why? Because of the fact
That we have stated in paragraph 7, my lord, that we were paragraph 7, paragraph page.
the provision enumerated and 20 has been specifically clarified that to determine the continuous area, he shall be deemed to be in continuous service under an employer for a period of 1 year. If the workman during a period of the calendar year month preceding the date with reference to which the calculation has actually worked under the employer for not less than 240 days. It may be immaterial that since when the workman is working and to ascertain the continuous service of last 12 period preceding the date with reference to which the calculation is taken. If the said single data becomes applicable where the service is less than 1 year till the cutoff date, that is Wednesday. In that case, service of the last 3 months is taken into consideration. So these people were all employed 19 days in a month. And therefore they don't get 240 days.
But here, my lord, when we were entrance, there was a finding that we have completed for 40 days. That matter, my lord, went to the score that outside.
Show me that. Asking you is difficult, you are not prepared.
No, no,
Where is
all
the
these
judgment?
records are there in my.
Where is the judgment of the apex court or the division bench?
Then you take no, the first of all, the representation of the affidavit in opposition filed by the
Page?
50.
This is Justice Rishikesh Roy's judgment.
My lord.
Huh?
Yes.
Where is the finding?
Our submission is noted down at page 1. Paragraph 7 on the thing. May I read?
Where is it said that it is to be retrenched? Yeah. It appears from the materials that are before this court that the retrenchment will retrench from service in the year 1993. Orders were interfered with by the Learned Industrial Tribunal on the ground that the order of retrenchment has been passed without fulfilling the year. They had held that no notice was issued in a year. It was also further found that no reason was also paid on the basis of the above. The post of deficiency notice in the retention, the lands are reinstated. Tribunal, the director reads, pursuant to upholding the report on by all the posts rejecting the financial that they have made against them, to be reinstated. And presently they are in service of the FCA, but in people person. Then they can be basically
Hello, this is the judgment of 18/7/2007. So after long 10 years, they have approached the Industrial Tribunal for regularizing their service.
No, it's okay. But first of all, your basic case is that they don't come under 25B. Now, where is that finding? That they are not casual, they are workers. Continuous period. You have made a submission now that they are, because you require to have a continuous period of 240 days. And that has to be taken with reference to the date on which preceding 12 months from the date of the period on which the reference is required to be taken. So if they are to take it on a particular date when you are claimed for the bonus, so you have to therefore look into the last 12 months and find out whether 240 days are there. But there is another thing that if this is being done in such a manner like posting them only for 19 days, knowing fully well if it is 20 days, it would now come within the ambit of 240 days. Now, to be entitled to the bonus, you are to be a workman. But a casual workman can also be a workman, provided he has 200 continuous service.
40 days is for the better for regular. But once this concept of payment of bonus act doesn't say so. 40 days is fine for regular.
Okay, let's come back.
Concern. Eligibility in section 8. Eligibility for bonus is in section 8 of the payment of bonus act.
Bonus is payable to whom?
Every employee to be defined by the. The employee to be entitled to pay rights employer and accounting year bonus in the employer's. This act provided year work in the establishment for not less than 30 years. So for not less than 30 working days in that year.
So it will come, a daily rated worker will also come in.
What is defined again in section? From section 13. What it means, other than an advantage, what and salary of wage one, 51,000 per person. Any industry, any skilled and unskilled manual supervisory managerial, administrative, technical or clerical work for hire or for. Whether the terms of employment be expressed or implied.
What do you say about the circular dated 9/9/96? Where is the document 9/9/96?
Please, okay.
Ah, got it. Exhibit 6. Yes, kindly come to serial number 2, paragraph number 2 of that notice dated 9/9/96 of the circular. Read it in your paragraph 2.
Further, on the demand of NCC of the CI employees, the matter was again examined and it was decided with the approval of the board of directors that the genuine leftover cases not be considered earlier for regularization of their services in terms of the board decision. 24/2/57 may be regularized. Accordingly, necessary instructions in this regard is given to all of ZMs, consultants, AMs, right, confidential data numbers, so dated 24/8/1993 to regularize services of all career daily rated employees who have continuously worked for more than 3 months on the date of 2/5/1986 and are fulfilling the conditions prescribed in the section. Later, dated 6/5/1987. Was also advised hearing that the case of daily rated employees in case on or after 1986 would be retrenched summarily by taking care witness of the company. Instead of being regularized, we were retrenched. In the earlier round by the 1996, when we approached the tribunal, it is 10 years we have served continuously and they would have record to that evidence. Therefore, retrenchment cannot happen. And our date of appointments are also might not recorded. That is as of 1984. So as per this particular number policy, 56 might not we already have 3 months service and all our colleagues might have were not retrenched, have been regularized.
What are the names of the respondents? Who are the persons concerned who are affected? For whom you are representing?
That's 6%.
Who are names?
Zogen Boro, Babul Das.
Huh?
Zogen Boro, Babul Das.
Robin Boro. Robin Boro, they say that he comes within the ambit.
No, they say that he has already crossed 60. The other day I stated that he has crossed the age 60.
He has retired.
He retired.
He crossed 60 years on 23 on 2024. Total election we have final addition.
Okay, what about the others?
And petition number 4 also has retired on 28/11/2020.
And the other,
The others,
other four are named?
other 4 are Babul Das, Tupuram Rama, Robin Purwa, and Gauri Sorondo.
So this very aspect about 120 days, 240 days have already attained finality in view of the judgment of Jain Sharma, Justice Jain Sharma, which have been upheld by the division bench in dated 23/9/2002. The period of the working of 200 hours shall be taken into consideration in a case a workman who has worked with the company for less than 1 year. It is for the purpose of calculation of the year's 240 days are to be taken into consideration where the workman is in employment of the year for less than a year. This provision has no application, he is working continuously. We find no illegality. So if this is the finding, how are you raising the same point again and again and again in respect to these persons? Because they were very much parties before Honorable Justice Jain Sharma then, as he then was, and then the matter came up before the appeal, the writ appeal that this is the judgment.
I'm relying on what has occurred 6 May 1987, which is the country regarding regular.
Now we'll look into that, but your question of 240 days has to be. It is absolutely encourageous on your part to keep on raising the same issue after against these very workmen. It has attained finality.
Either way, it has been observed that they were working in casual.
No, whatever may be, but this has attained finality. This respect, this is the law. I can't touch this. It's, after all, the division bench judgment of this in a writ appeal number 446/2001. And then also, they are still continuing, and it is an admitted fact that you are rendering, asking them to work for 19 days. You can't raise that issue any further.
Not the effect B. The effect B for 1 year, my lord, it is okay. For 1 year, 240 days.
Huh?
But if it is a continuous appointment for number of years, then it is going to take B.
Fellow, we dismiss, we allow his petition and you dismiss your petition. But this should be with cost. This is absolutely courageous type of litigations, going on and on and on. And being a state, we should impose a cost of 1 lakh. Unnecessary litigations going on. heard Mr. B.K. Singh, the Learned Counsel, appearing on behalf of the Food Corporation of India, Mr. B. Pathak, the Learned Counsel, who appears on behalf of the respondents' workmen. Two petitions have been filed. Now, each of the parties, that is the Food Corporation of India as well as the respondent workmen, have filed the present two writ petitions assailing the award dated 9/12/2019, passed in reference case number 1/2018. First, the petitioner, Food Corporation of India, is the writ petitioner in WPC number 2429/2020, whereby the award dated 9/12/2019, passed in reference case number 1/2018, have been assailed on the ground that the Food Corporation of India were directed to pay the bonus to the concerned workers involved in the reference with effect from the year 2003 as per the applicable rates till the date of the award, and with a further direction that the payment of the bonus shall also continue thereafter till such days the concerned workers are in employment of the management. The petitioner, the workmen in question, are the writ petitioners in WPC number 2092/2021. And they are aggrieved by the award dated 9/12/2019, passed in reference case number 1/2018 on the ground that the award, there was no direction for regularization of their employment passed by the Learned Industrial Tribunal, Labour Court, na? Learned Industrial Tribunal, come Labour Court, Guwahati. Before proceeding to adjudicate in the respective issues raised in both the writ petitions, this court finds it relevant to take note of the brief facts which led to the filing of both the writ petitions. It is the case of the respondent workmen. It is the case of the workmen who are the petitioners in WPC number 2092/2021. That they have been rendering service in the establishment of the Food Corporation of India, bracket FCI. On regular basis as a casual worker. In the claim statement so filed by the respondent, by the workman, MEN, the details are provided in paragraph 3E of the claim petition. Number one, itu this is the page 20. The chart so mentioned in the said paragraph is reproduced here in under. From the same chart, above mentioned chart, it is seen that all the 6 workmen were engaged by the respondent, by the FCI, sometime in the year 1982 to 84. The materials on record further reveal that the FCI took steps for regularization of its work of the casual employees. And in that regard, had issued a circular dated 6/5/1987 wherein it is mentioned that casual/daily rated workers who have completed 3 months period on 2/5/1986 and fulfilled the conditions prescribed for any entry-level category Roman 3 and Roman 4 would be regularized. It is the case of the workmen that though large numbers of casual workers were regularized, but many of them were also left out, including the workmen. Though they were qualified to be regularized. Subsequent thereto, another circular was issued bearing circular number 38/1996, dated 9/9/96. Wherein also the FCI took a decision to regularize all casual/daily rated employees who had continuously worked for more than 3 months on the cutoff date dated 2/5/1986 and fulfilled the conditions prescribed in the EP section, confidential letter number EP.1/4/85- Roman 2, dated 6/5/87. It was also mentioned in the state circular that casual/daily rated employees engaged on or after 2/5/1986 could be retrenched summarily by paying them retrenchment compensation. It is also very pertinent to take note of another very relevant aspect as it appears from paragraph number 5 of the circular dated, paragraph number 3 of the circular dated 9/9/96, which stipulates that many casual/daily rated workers are still continuing and the officers officers of the FCI continue to engage casual/daily rated workers without specific approval of the headquarters, in spite of engagement of the casual workers. In spite of and on engagement of casual workers. The record further reveals that the petitioners herein, the workmen herein, along with 3 others, the services of the workmen herein, along with 3 others, were terminated with effect from 9/2/1993. This resulted in an industrial dispute. And under such circumstances, the appropriate government made a reference in terms with section 10, 10, reference is made under 10 or 10A. 10. Oh, you both of you do industry labor 10 or 10A. You don't have the book also. 10 or 10A, reference 10. Huh? Huh? That's how the deal.
That is reference of this good.
Under section 10 of the Industrial Disputes Act 1947, hereinafter referred to as the Act of 1947, to the Industrial Tribunal, Guwahati. On the basis of the said reference made to the Learned Industrial Tribunal, Guwahati, a case being reference case number 1C/1994 was registered. In the said proceeding, the stand which was taken by the FCI were that these 9 workmen, which included the workmen of the present proceedings, not be entitled to any benefit under section 25F, any protection under section 25F of the Act of 1947, as they were not in continuous service in the industry. The Learned Industrial Tribunal passed an award on 24/4/1995 holding inter alia that a workman in the said industrial disputes proceedings, were entitled to the benefit under section 25F of the Act of 1947. And as steps were not taken in accordance with section 25F of the Act of 1947, the retrenchment, so the termination of those workmen were invalid. Be that as it may, a very important aspect which touches on the present proceedings was discussed and opined in the award dated 24/4/1995. It was categorically opined that the workmen in those cases, it was categorically opined that though the management have alleged that the workmen have worked for 19 days in a month and they were paid their wages at the end of the month, but from Exhibit Ko, Kho, Go, Ho, and Ungo, where bonus registers showing payment of bonus every year to these workmen against their wages for 19 days in a month. It was further opined that counting the period of 240 days come only where a workman is not in continuous service within the meaning of clause 1 of section 25 capital B of the Act of 1947 for a period of 1 year. However, the said question of 12 months, however, it was further opined that counting of 240 days for a period of 1 year is relevant if the employment does not exceed 1 year. But when the employment exceeds 1 year, counting of 240 days in a year is redundant. A challenge to the impugned award dated 24/4/1995 in reference case number 1 bracket C of the year 1994 was made before this court. By the FCI in a writ petition which was registered and numbered as WPC number 4274/1996. The learned coordinate bench by an order dated, judgment and order dated 3/4/2001 upheld the award dated 24/4/1995 passed by the learned presiding officer and passed by the Learned Industrial Tribunal, Guwahati, in reference case number 1, bracket C of 1994. The parties to the said writ petition includes the present workmen who have filed WPC number 2092/2021. The FCI being not satisfied with the judgment passed by the Learned Coordinate Bench dated 3/4/2001 in WPC number 4 in Civil Rule number WPC number 4274/1996 preferred a writ appeal which was registered and numbered as WA number 446/2001. And the Learned Division Bench of this court by an order dated 23/9/2002 dismissed the said writ appeal. The order dated 23/9/2002 being relevant for the purpose of disposal of the instant proceedings is reproduced herein under. Where is that order?
Page 52.
Page?
52 annex of
Whose writ petition?
minor.
2092, page 52. Huh? Annexure?
Fine. So 7 minor, page 55, SLP is also discussed.
Where is it? It is seen that pursuant thereto, the FCI approached the Supreme Court of India by filing a special leave to appeal. The Supreme Court of India the Supreme Court by an order dated, where is that order?
Page 55, annex of 7. Forty-seven. 2003.
14/7/2003 dismissed the special leave petition, which was registered and numbered as special leave to appeal bracket civil 5559/2003.
Thereafter, everybody is the reinstated on 24/9/2003.
Huh?
Circular thereafter reinstated on 24/9/2003.
So there is another reference, no? Another reference.
No, ma'am.
Why you have the order of Justice Rishikesh Roy?
Thereafter, they arranged for the regular. And the writ petition says that it will actually itself that.
Where is the writ petition?
Page 58, page 58.
Huh?
Page 58 annex.
Whose petition? Huh? Give me one writ petition index
Page 58.
of 2092. The record further reveals that the petitioners, the workmen, continued to render services and were engaged as casual employees. The respondent, it is the further case of the workmen that instead of regularizing the services of the workmen who have been engaged as casual employees, Food Corporation, FCI, took steps for filling up the vacancies by way of a special recruitment drive. Isn't it? It is under such circumstances the workmen in question, along with the Food Corporation of India Workers Union, joined together and filed a writ petition before this court, being WPC number 1390/2005. Whereby the workmen sought for a direction for regularization of their services in terms with the policy adopted by the Food Corporation of India. The same writ petition, which was registered and numbered as WPC number 1390/2005, was disposed of by the judgment and order dated 18/7/2007. Whereby the learned coordinate bench observed that it would not be justified in directing the regularization of the services of the petitioner or of the workmen without being posted on the position prevailing in the respondent corporation, in the prevailing in the FCI, as on the date of the said judgment, inasmuch as the circular on the basis of which the workmen claimed regularization was dated 6/5/1987, which was 2 decades old. The learned coordinate bench also observed that taking into account the judgment of the Supreme Court in the case of Uma Devi, the case of Secretary Karnataka, State of Karnataka and others versus Uma Devi, reported in 2006 4 SCC 1. The court would not be competent to pass orders for regularization of the services of the workmen, and such orders would be clearly contrary to the law laid down by the Supreme Court. It was, however, it was further observed by the learned coordinate bench that the non-entertainment of the writ petition should not be understood to mean that this court have given a finding that the workmen were not at all entitled to have their services regularized. If otherwise, they can establish the right for such regularization as envisaged under the industrial law, and liberty was granted to the workmen to take recourse to such measures as may be available to them under the law for that purpose. Where's the reference notification?
Check and it's referring to reference my worker is not there. But then after consideration, thereafter the reference one of 2008.
You filed under 2A. Did you file it under 2A? How did you approach the court? No. Ministry was referred. Ah. I don't know. It was referred. Okay, let me come back. You go and see. Don't have your lunch. Have a look at it. And then we'll consider. Again, further dictation to come.
After 2007, they have approached only year 2008 for their regular. The 2007, that judgment of the coordinate bench, that they may approach the.
But you see, you have not challenged the award, nah? You should have challenged the notification. You can't raise these things. And what about the bonus?
Bonus taken. I'm not on bonus, I'm on regular.
Regularization is, we have to give as per that. I have not given any regularization in my last 4 years. Let me start with this one. And I have to be very careful because this has to be, therefore, the question is, we have to bring it under the industrial law. Otherwise, it will have far-reaching consequences in the other matters. But I think Dharam Singh can be brought in, taking into account there also the same schemes are there. And the directions and the certain directions which were passed in Dharam Singh, the later part, I think these can be given. And even you can get those persons who have retired also will get benefit in terms with Dharam Singh. Don't you think so?
Similar government has been reserved by our division bench, where I appeared for the PSL. Of course, there we have to regularize them. The casual employees and my team.
Division bench also passed an order.
Judgment is reserved. Judgment is reserved.
No problem. I think there, those 2 persons who retired also can benefit in view of the Dharam Singh.
Yeah.
Let us give them people.
I'm relying on the those case method. So far as giving benefits of it's concerned. That was.
You rely whatever may be. This is my opinion I will give. For you to go to the division bench is much better. My only thing is, from my side, I complete it. Then leave your ball to your courts. Court reveals that the Ministry of Labour, Government of India, New Delhi, by an order number L-22011/23/2017-IR bracket CM-Roman 2 capital bracket close dated 11/12/2017 made a reference to the Learned Industrial Tribunal. The questions referred reads as under page 134. Schedule 2. Questions referred in the communication in the schedule to the communication reads as under. Pursuant to the reference so made, the proceedings were registered as reference case number 1/2018. The record reveals that the workmen submitted their statement of claim, and the FCI also submitted their written statement. On behalf of the workmen, 6 witnesses were examined. Who were also cross-examined by the FCI. However, on behalf of the FCI, there was no evidence adduced. The Learned Tribunal, by the award dated 9/12/2019, held that the workmen were entitled to bonus under the Payment of Bonus Act 1936, 1965, with effect from the year 2003. However, on the question of regularization, the said was turned down by the Learned Labour Court. Resultantly, the present two petitions have been filed. By five. One by the FCI challenging the directions for payment of bonus with effect from the year 2003. And the other by the workmen challenging the rejection of their claim to regularization. Submissions on behalf of the learned counsels appearing on behalf of the parties. Heading. Who wants to make the first submissions? You. You say, because you are the main person.
about payment of bonus and pay sponsor. The definition of our employee and entitlement to bonus under section 8 by law covers our case. There is also been earlier recorded by the industrial tribunal that bonuses were earlier paid.
Bonus in his case. You come in your case.
As far as regularization, tribunal says that there is no material to prove that they were working prior to 1986, which is contrary to the findings that was arrived at in the earlier reference that was made, where it was saying that in 1993 we had already completed 10 years of service.
Where is the finding?
My recognition is for Roxin Thomas.
আমরা চারক্ষণ বনাবো
Base
শুনো
certificate.
পেজ 88 পাই যাবে হ্যাঁ রিপিটিশন where is that?
Page 35. Like I must say that the offer prevention of 10 workers from service of the more than 10 years of continuous service. Federal law and its officers. But again, page 34, of the second paragraph. Page 34, second paragraph. In the instant case, all casual workers were retrenched in 1993, worked continuously in 3 months as of 2/5/1986. But for more than 3 years, is the clear violation of the provisions of circular 2/5/1986. Their retrenchment after 10 years of continuous service is not only violated of the provisions, but is also in violation of the provisions of the Industrial Disputes Act 1947.
Mr. B. Pathak, the learned counsel appearing on behalf of the workmen, submitted that the learned labor court, while deciding the issue pertaining to regularization, have failed to take into consideration the award passed by the learned labor court, by the learned industrial tribunal, dated 24/4/1995, in reference case number 1(C) of 1994, wherein there are categorical observations that the workmen have been under employment for a period of more than 3 years, as on 2/5/1986, and as well as also categorical observations that the workmen concerned were rendering service for the last 10 years, rendering continuous service for the last 10 years. The learned counsel further submitted that these findings have attained finality in view of the award having been upheld, award dated 24/4/1995 having been upheld right up to the Supreme Court. The learned counsel further submitted that at paragraph number 3C of the statement of claim, various details have been given as to from when the workmen have joined service and were rendering their continuous service as casual employee. Further referring to the written statement filed by the respondent, by the FCI. The Learned Counsel submitted that there is not any denial to the said aspect. Rather, it was only merely a vague denial that the petitioner had been working continuously without any break in service and they were engaged on regular basis. Full stop. Under such circumstances, the Learned Labour Tribunal ought not to have rejected the claim for regularization on the basis that there were no specific material to show that the petitioner, the workmen, were rendering service prior to 2/8/1986. Full stop. The Learned Counsel further submitted that a perusal of the circulars dated 6/5/1985, 86, na?
86.
6/5/1986, as well as 9/9/1996, would categorically show that there was an attempt made by the FCI for the purpose of regularization of all casual employees who have worked for 3 months prior to have rendered 3 months continuous service prior to 6. What is the date? Huh? Dated 2/5/1986. Full stop. These schemes, which were announced while carrying out, the Learned Counsel further submitted that the respondent authorities, for reasons best known, the FCI, for reasons best known, did not consider the case of the petitioner. Though the petitioners were eligible to be regularized as far back in the year 1986, or even in terms with the circular dated of the year 1996. In that regard, the Learned Counsel referred to the judgment of the recent judgment of the Supreme Court in the case of where? Which one?
2025. The online SP 1775.
Where is that? Dharam Singh and others versus State of UP and another reported in 2025 SCC Online SC 1735, wherein the Supreme Court issued various directions for regularization and creation of supernumerary posts, have issued various directions in paragraph number 19. The Learned Counsel submits of the said judgment. The Learned Counsel submits that the facts involved in the present case are similar, taking into account that the respondent authorities have continued to take the services of the petitioner for the last 3 decades and have not regularized their services. Anything more on regularization? Anything more on regularization?
This previous thing about the judgments of Vinod Kumar, Zargo and Sripal are all discussed in this petitions. So I'll not give it.
He further submitted that in the judgment rendered by the Supreme Court in the case of Dharam Singh Supra, various other judgments rendered by the Supreme Court in the case of Sirpal versus Nagam Nigam Ghaziabad, reported in 2025 SCC Online. The Learned Council further submitted that similar observations have also been made by the Supreme Court in the cases of Vinod Kumar and others versus Union of India and others, reported in 2024 9 SCC 327. Jago versus Union of India and others, reported in 2024 SCC Online SC 3826, as well as Sirpal and another versus Nagam Nigam Ghaziabad, reported in 2025 SCC Online SC 221.
Regarding this previous petition, 1319 of 2005, where the court said that in view of Umar Devi, we cannot pass any order, but we can go to the industry practice. So there is a reference to that extent that Umar Devi does not discuss the powers of industrial tribunals. And as far as unfair trade practice is concerned, industrial tribunal has full powers irrespective of Umar Devi concept. That is my lord, 2005, 780. Durgapur Cable Workers Union versus Food Corporation of India. There are 21 members.
The Learned Council for the petitioner further submitted that the basis on which the Learned Council further submitted that though the Supreme Court in the case of Uma Devi Supra may have issued directions that a court cannot direct regularization. It cannot issue a writ in the nature of a writ for regularization of a workman or of an employee. But the same aspect, but the same directions would not, however, apply to an industrial adjudication, an adjudication made by an industrial tribunal. In view of the judgment of the Supreme Court in the case of Durgapur Casual Workers Union and others versus Food Corporation of India and others, reported in 2015 5 SCC 786, the Learned Council further submitted the reason behind is that the aspect pertaining to unfair labor practices can be very well gone into by the industrial tribunal, and one of the questions so referred by the central government in the reference was as to whether the not regularizing the workmen constituted an unfair trade practice, labor practice. Anything more? He further submitted that though a writ petition has been filed by the FCI challenging the directions for payment of bonus, in view of the definitions contained in Section 213 of the Payment of Bonus Act 1965, definition contained of workman or employee in Section 213 bracket 13 of the Payment of Bonus Act 1965, or short the Act of 1965. The directions so passed by the Learned Industrial Tribunal in the facts of the case do not require any interference. Yes, Mr. Singh, what is your submission?
39 bonus partner. I think wrong in my paragraph 18 and 19.
Bonus. Bonus, you have not said a single thing in your written statement.
The written statement I have got.
Then there was no case, there is nothing mentioned out there. But otherwise also you don't come in. No
That
case.
is true, we have not taken any stand in the, that is true that we have not taken any stand in the written statement. Before the industrial tribunal.
Mr. B.K. Singh, the learned counsel appearing on behalf of the FCI, submits fairly that though in the written statement filed in the reference proceeding, there was no specific stand taken in respect to the entitlement of the bonus to the workman, but it is the practice followed by the FCI not to grant bonus.
It is incentive.
Rather, incentives are provided. I think you should not say that, because if I say that, I will say that it will have, means it will have, I say that, I will have to say that you are liable for bonus. Then the fact, what will happen is,
That may not be recorded.
no, the fact what may happen is, they will open up every case. You understand that the ramification of my order will happen that the labor commissioner will open up each and every case. Because incentives cannot be, you are liable to pay as per the bonus act. What do you say then? What is your submission?
And that may be recorded then. Bonus is liable to be. Bonus may be is liable to be.
Wait, I think that is better. Yeah, because otherwise, if that is a finding, it will have far-reaching consequences.
Earlier, one of these bonus registers might have been produced in the earlier order.
Let it be.
2003, might not bonus.
Mr. B.K. Singh, the learned counsel who represents the FCI, submitted the materials on record shows that materials on record, and more particularly the findings in the award dated 24/4 to 1995 in reference case number 1C/1994 show that till 2003 the FCI paid bonus. However, as the petitioner's workman in question did not render continuous service of 240 days in a year, the workmen are not entitled to bonus. I think that is saving it. Okay, now regular. Yeah.
And regularize and.
No, regularization come. This is for bonus. Okay,
They have
regularization.
not been able to prove that they have not been paid bonus by law. Only a one line they have stated in their statement that we have not been paid for. Only one line.
Is it your stand that we are paid with bonus? Don't come up with that.
As stand taken in my paragraph number 19, my lord,
Of the writ petition.
of my writ petition.
No, there.
Here, my lord, we have not taken any stand.
So that is why, kindly come to regularization. Let me take up. I'll take care of that. What is your on regularization?
Yes, regularization, my lord, there was a writ petition by the employee, my lord, workman, casual worker. That by order dated, coordinated with the director general approach the Union Industrial Tribunal. And they have approached only after the year 2018. The order was of 2007. So if your lodging is giving a regularization, it may not be a retrospective effect, but from 2018, when they have approached the Industrial Tribunal. And I am relying on Jumbo's case, where it has been stated that the workmen, they have not worked. For that period, they may not be the relevant paragraph matter.
Of Jabo. Which paragraph?
Paragraph 28.
In view of the way the appeals are allowed, the impugn orders of the High Court, the termination order, the cause, the appellant shall be taken back on duty and forthwith and their services regularized forthwith. However, the appellant shall not be entitled to any pecuniary benefits, back wages for the period they have not worked for, but would be entitled to the continuity of service for the said period. And this has no relevance. The reason why it is because they would not get the back wages for the period where they were terminated. You have to understand that in the context in which it is being said. You say, let us make your services. The taking into account that the petitioner, the workman never approached after 2007, but approached and the reference was in 2018. Under such circumstances, the benefits of regularization, if so granted, can only be prospective from the date of the notification issued by the central government. I think that is a fair, better submission. Huh?
On that, prior to that, after the 2007 judgment, they had recommended our name several times. Ultimately, in 2015, conciliation proceedings started, re-reference. Then in 2017, another reference.
Okay, Mr. B.K. Singh, the learned counsel appearing on behalf of the FCI, submitted that there is no infirmity in the impugned award dated so and so, in holding that there were no materials placed that the petitioners have worked prior to 25/2/1986, isn't it?
Yes, ma'am.
And had the requisite qualification to be entitled for regularization in terms with the circular dated so and so 1986 as well as so and so 1996. So, the learned counsel further submitted that the petitioner had earlier approached this court seeking directions in petitioners have earlier, the workmen have earlier approached this court seeking directions upon the FCI that the workmen should be regularized. The learned coordinate bench, by the judgment and order dated so and so, in WPC number so and so, rejected such a plea. This rejection was in the year 2007, and thereupon a reference had been made in the year 2018. And thereupon, the reference had been made in the year 2017 by the central government, by the government of India. First, the delay in making the reference. Under such circumstances, the reference so made was a stale reference, inasmuch as there was no industrial dispute in existence. The learned counsel further submitted that the delay in making the reference in the year 2017 have also caused great disadvantage to the FCI for the purpose of adducing evidence inasmuch as the witnesses at that relevant point of time were no longer available. Better na? Submission. Mr. B. Pathak, replying to the submissions made on behalf of the workmen, however, submitted that
It can't be recorded that
witnesses were not available. As taken in
There was no management witness.
management.
Therefore, your stand.
That-
You take
because
that
of that, we
plea.
have not used the witness, that is not there on record, but simply we have not used any witnesses. By the
So,
management.
you see, have you ever gone into and read the judgment of Salimar Paints? Read the judgment. Tomorrow, if you want, your FCI wants to challenge it, can take this plea there and take there. Salimar Paints, 1979. Have a look at it. I'm helping you out and you are. If I don't say that, if you don't want, I can remove it, but it is, that will affect you. This is good for you. Because you have not adduced evidence, nah?
Yes.
So it goes with the flow. Mr. B. Pathak, the learned counsel, appearing on behalf of the workmen, however, submitted that the authorities in the FCI pursuant to the order passed by the learned coordinate bench, the judgment and order passed by the learned coordinate bench dated so and so in WPC number so and so, had recommended the names of the petitioners for regularization. However, the authorities, however, the Food Corporation of India, FCI, did not agree to the same, resulting in a conciliation proceedings in the year 2015. Huh?
13/7/2015.
13/7/2015. And these conciliation proceedings having failed, the reference was made by the central government on 11/12/2017. Anything more? Sure. Analysis and determination. From a hearing, upon perusal of the materials on record and hearing and taking into account the submissions so made by the learned counsels appearing on behalf of the parties, 2 points for determination arises for consideration. Number one, whether the impugn award dated so and so, thereby directing the FCI to pay to the petitioners the bonus with effect from the year 2003 as per the applicable rates till the date of the award, as well as to pay future bonus till the workmen are in service, are in employment, calls for any interference. Number two, whether the impugn award thereby rejecting the claim of the workmen for regularization calls for any interference. First point for consideration, the heading. Huh? For determination of consideration. Huh? Sure. This court had duly taken note of the materials on record including the statement of claim and the written statement filed by the parties before the Learned Labour Court, Learned Industrial Tribunal in reference case number 1/2018. In the claim petition so filed by the workman, it has been categorically mentioned that the petitioner, that the workmen were earlier paid bonus since 1982, which was stopped or withdrawn with effect from 24/9/2003. The respondents, however, the FCI, however, have not denied the said claim made in the statement of claim by the workman. What was emphasized by the FCI in their written statement is that workmen were in lack of continuous service at least for a period of 20 days in a month or 240 days in a year. Which clearly differentiates the workman from the status of regularly working workmen in continuous service without any break. The question therefore arises is as to whether the workman having not 240 days of employment in a year would deprive the workman of the benefits under the Act of 1965. A perusal of the Act of 1965 reveals that the said Act was enacted to provide for payment of bonus to persons employed in certain establishments on the basis of profits or on the basis of production or productivity and for matters connected therewith. Which are the establishments which should be covered have been mentioned in section 1(3) of the Act of 1965. It is relevant to observe that the FCI have not taken a plea that it is exempted in terms with the proviso to section 1(3) of the Act of 1965. This court further finds it relevant to take note of the definition of employee as defined in section 2(13) of the Act of 1965, which being pertinent to the adjudication of the present adjudication of the present dispute is reproduced hereunder. A perusal of the above quoted section would show that an employee mean any person bracket other than an apprentice bracket close employed on a salary or a wage not exceeding 2,000 21,000 rupees per mensem in any industry and to do any skilled or unskilled manual, supervisory, managerial, administrative, technical, or clerical work for hire or reward, whether the terms of employment be express or implied. It is further relevant to take note of that the amount mentioned of 21,000 per mensem was earlier, prior to 2016, prior to 1/4/2014, was rupees 10,000 per mensem. Nothing has been placed before this court. Neither there is any pleadings on behalf of the FCI, nor anything has been placed before the Learned Industrial Tribunal, nor before this court, that the employee, that the the present workmen do not come within the ambit of the definition of employee as defined in section 213 of the Act of 1965. Section 8 of the Act of 1965 stipulates the eligibility for bonus. The said section being relevant is reproduced hereunder. A perusal of the above section, quoted section, would reveal that every employee shall be entitled to be paid by his employer in any accounting year bonus in accordance with the provisions of the Act of 1965, provided he had worked in the establishment of not less than 30 working days in that year. There is nothing on record to show that the petitioner, it being an admitted case of the respondents of the FCI, that the petitioners the workmen have rendered service every month for 19 days. Come on. It is therefore the opinion of this court that the workmen are entitled to bonus in terms with section 8 of the Act of 1965. Considering the above, it is therefore the opinion of this court that the Learned Industrial Tribunal was justified in directing the in awarding that the petitioner, the workmen are entitled to bonus with effect from 2003 onwards at the appropriate rates, and would be further entitled to the bonus till the workman continues to render service in the management. In the backdrop of the above, now come to this answers the first point for consideration. Number 2. Second point for consideration. The second point for consideration pertains to as to whether the workman would be entitled to workmen. Second point for and the second point for consideration is as to whether the learned industrial tribunal was justified in rejecting the claim of regularization of the workmen. It is relevant to take note of. The in the previous segments of the instant judgment, this court have provided the details as stated in the statement of claim as to when the workmen who are the petitioners in WPC number 2092/2021 joined their services and have been rendering service as a casual employee. This aspect have been duly mentioned in the statement of claim. There is no denial to the said aspect. There is no specific denial to the said aspect. Rather, it is the case of the petitioners of the FCI that these workmen have not rendered continuous service for a period of 240 days. It is further pertinent to take note of that this very issue was raised by the FCI in reference case number 1/C/1994. And the Learned Industrial Tribunal, by the award dated 24/4/1995, categorically opined that the said requirement of having 240 days working for 240 days would be only applicable if it is a question that would only be applicable in respect to a workman who has worked with the company for less than a period of 1 year. But the said aspect would, however, not be applicable where the workman is in employment of the company for more than working in the company continuously with the company for more than a year. This observation so passed by the Learned Industrial Tribunal in the award dated 24/4/1995 vis-a-vis the FCI and in a dispute between the FCI and the workmen of the present case have attained finality, taking into account that not only the Learned Coordinate Bench, the Learned Division Bench, but also the Supreme Court had upheld the said observations. Under such circumstances, the plea so taken by the respondents, by the FCI, that the petitioner, that the workman did not render service for 240 days, continuous service for 240 days, would not therefore disentitle the workman in the present facts of the case. The records further revealed that in the opinion, in the award dated 24/4/1995, the Learned Industrial Tribunal had categorically observed that the workmen in the said reference proceeding, which included the workmen of the present requisition. As on 2/5/1986, have not only rendered 3 months and have not only rendered 3 months, but more than 3 years. It was also opined that the workmen have rendered 10 years of continuous service. Additionally, it was also opined that to terminate those workmen was in clear violation to the circular dated 2/5/1986. At the cost of repetition, this court finds it appropriate to observe that this circular dated 2/5/1986 is a circular by which the FCI took a decision to regularize those casual/daily rated workers who have rendered 3 months continuous service prior to 2/5/1986. These findings of facts to arrive at have attained finality. The respondent authorities, it is very strange. It is really surprising to take note of that the learned Labour Court, while addressing the issue pertaining to regularization, simply rejected the claim by stating that the petitioner, but the workmen failed to produce, have not produced materials that they have been in service prior to 2/5/1986 and had the requisite qualifications. It is not the stand of the respondent of the FCI at any stage that the workman did not have the requisite qualification. In this regard, this court finds it very pertinent to take note of the judgment of the Supreme Court in the case of Dharam Singh Supra, wherein the Supreme Court was taking into consideration as to whether those employees who were rendering service as Class 4 employees between 1989 and 1992 as Class 4 employees, as well as driver those employees who were rendering service as class 4 employees between 1989 and 1992. And their services have been continued from time to time. They should be regularized or not. The Supreme Court, referring to the judgment of the Constitution Bench of the Supreme Court in the case of Uma Devi Supra, categorically observed that the said judgment of the Constitution Bench was not to non-suit the appellants therein, inasmuch as what was challenging those proceedings is not to bypass the constitutional scheme of public employment, but rather was a challenge to the state's arbitrary refusal to sanction posts despite the employer's own acknowledgement of needs and decades of continuous reliance on the very workforce. This court finds it relevant to take note of the observations made by the Supreme Court in the case of Dharam Singh, more particularly at paragraph number 11, wherein the Supreme Court further referred to the judgment of the Supreme Court of further judgments of its referred to its other judgments in the case of Jago Supra, Sirpal Supra, and Sirpal Supra. Paragraph number 11 of the said judgment being relevant is reproduced hereunder. In the backdrop of the proposition so laid down, this court now again finds it relevant to take note of the circular dated 9/9/1996, the reference of which was made in the previous segments of the present judgment. In the said circular, it was categorically mentioned that there should not be any further continuation of casual or daily rated workers. However, it is seen that the respondent, the FCI, continued to engage the petitioners as workmen, and still four out of the 6 workmen are presently engaged with the respondent, with the FCI. This court now further finds it relevant to take note of the observations of the Supreme Court in the case further observations of the Supreme Court in the case of Dharam Singh, more particularly paragraph 18, 19, and 20, as the same has relevance in the present case. The same are reproduced hereunder. A perusal of the above observations and directions, in the opinion of this court, squarely applies to the facts of the instant case. Inasmuch as, in spite of circulars being issued, the respondent authorities, the FCI continued to engage the petitioners and thereby not creating posts. Let's go next. At this stage, this court finds it further pertinent to take note of the submissions so made by Mr. B.K. Singh, the learned counsel appearing on behalf of the FCI, who submitted that after the year 2007, after the judgment passed by the learned coordinate bench dated so-and-so in WBC number so-and-so, the reference was made only on 11/12/2017. And it was a delayed reference. And as such, the petitioner, the workman cannot be entitled to any, even if directions are issued, they would not be entitled to any pecuniary benefits prior to their regularization. It is seen from the materials on record that pursuant to the judgment passed by the learned coordinate bench, there were materials on the bench, comma. The dispute between the workmen and the FCI as regards the aspect pertaining to regularization continued. And in that regard, it led to a stage of conciliation proceedings. The conciliation proceedings having failed, the same led the central government to make a reference by the order dated 11/12/2017. This notification has not been put to challenge. Rather, the FCI continued to participate in pursuance to the said notification of making the reference. This court further finds it relevant again to refer to the judgment of Dharam Singh, and more particularly to paragraph number 19, which have already been quoted herein above, wherein certain directions were passed as to how the regularizations should be carried out. It is the opinion of this court that taking into account the directions passed by the Supreme Court in paragraph number 19, the petitioner, the workmen out here, would be entitled to regularization. The date on which the regularization has to be given effect to would be the date on which the reference was made by the central government, that is on 11/12/2017. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. Number one, WPC number so and so. WPC number 2429/2020 filed by the FCI challenging the award dated so and so in reference case number so and so. Itu এই নতুন দুধ, হ্যাঁ? Insofar as directions issued for payment of bonus to the workman is dismissed. Number two, the FCI is directed to regularize the workmen, the petitioners in WPC number 2092/2021 with effect from 11/12/2017. That is the date on which the central government made the reference. Upon regularization, each of the petitioners shall be placed at not less than the minimum of the regular pay scale for a post with protection of the last drawn wages if higher, and the petitioners in WPC number so and so shall be entitled to subsequent increment in the pay scale as per the pay grade. Further to that, for seniority and promotion, the service shall count from the date of regularization as given here in above. Anything more?
1 and 4 have retired. That is.
This court further observes that taking into account the observations made by the Supreme Court in paragraph number 19, no, you get the benefit, nah. 1 and 4 will get them because I'm giving it from 1/12/2017. This court further clarified that taking into account the observations made by the Supreme Court in the case of Dharam Singh Supra at paragraph number 19(3), comma, as petitioner number 1 and 4 have already retired, they shall be granted regularization with effect from 11/12/2017 until the date of superannuation for pay fixation, arrears, and calculation of pension, gratuity, and other terminal dues. This court further, for the sake of clarity, observes and directs that any payment made during this period while engaging the petitioner shall be set off, while the petitioners in WPC number shall be set off while making payment by the petitioner, by the FCI to them in consequence to the directions passed here in above. So whatever payment you have made, that will be done. Now, Mr. Pathak, you have finished 5 matters of yours.
But except to pay.
What is this?
Gate is better as because it is 37/2025. Can be superseded by the because it is death by the presentation. Okay. President.
Yes, how do you take care of it now in view of this? Because your reasons therefore, because you, in the tender notice, it is categorically mentioned, it will be as per the procurement rules. Now, in terms of the procurement rules, it is not even an advisory, it's a notification by the governor of SAM. So therefore, you are bound by that. So your very basis on which for rejection goes for a 6. You do one thing, let us have this on Thursday at 10:30. You obtain your instructions, because today, if it is you say anything out there, it may be, your department may say something else. And again, another problem may arise with your departments. The 3 departments, I am very careful nowadays. Forest, EC, Excise. When these 3 departments are before me, I give the council another further chance so that later on the inter se councils of the same departments do not contradict against each other.
Subgroup 5, very clear. Security will be driven by the government, but by a notification. Notification.
So therefore, I am asking, no, therefore, I give him one chance. Observing this, I give you a chance, in the instructions. What do you say? You may take a decision for cancelling your decision. Or should we have it on next Tuesday? Next Tuesday. In the meantime, you may take as regards the impugn order, you may and go ahead with the tender if you feel so. Because otherwise you may have up later on a big problem as that. Pursuant to the order passed by this court on 10/11/2025, Mr. B. Gogoi, the learned additional advocate general, who is also the standing counsel of the finance department, has placed before this court an instruction dated 21/11/2025, issued by the Joint Secretary to the Government of Assam Finance Establishment Department, wherein it is mentioned that the notification issued by the Finance Department on 30/7/2024 would hold the field and is a prevailing guideline for handling abnormally low bids and provides for use of additional performance security where it is required. It is also mentioned in the said communication that the rejection of the bids based on plus minus 10% limit is not in line with the Finance Department's procurement framework. So considering the said instruction, the said instruction is kept on record and marked with the letter X. X, no Y. Mr. R.R. Gogoi, the learned counsel, appearing on behalf of the Forest Department, Forest Department, submits that in view of the said observations made by the Finance Department, he would like to obtain instructions. List this matter on 9/12/2025 at 10:30 a.m. for final disposal. Interim orders passed earlier shall continue in the next. তাতে এই জাজমেন্ট কিটা ভৰাই দিব হা লাইন এটা ভৰাব আছে বেলেগ
Item 4, fixed the
PK Garodia Learned Counsel submits that an affidavit has been filed with, however, the same is not taking into account that this is an application. Yes. So if this is a 17B application. I'll help you.
The applicant for date or hour, on the date or hour.
Understood, but the fact remains, as on 2024, you have already become 58. We're in 2025. So as on now, you cannot get because your age was till 58. So therefore, I have to reject this application. But you say that he's an old citizen. He's a senior citizen, not a senior also. Senior citizen. No, the but problem arises, Mr. Counsel, is this. Your application has to be filed. There has to be first you coming up before the court. In fact, if we see this application was filed by you on 25. On the same date, unless you have any other document, you say that you are 57. This can't be true. If on 22/12/2022,
Yes, sir.
you were 57. You should have been more careful. Now, heard Mr. S. Das, the learned counsel appearing on behalf of the petitioner, Mr. P.K. Garudia, learned counsel appears on behalf of the respondent. This is an application filed under section 17, capital B of the Industrial Disputes Act, 1947. Full stop. The case of the petitioner applicant herein is that the applicant pursuant to his termination in the year 2017, termination pursuant to 5/2/2016 is unemployed. Full stop. And under such circumstances, the applicant have sought for benefits and in terms with section 17, capital B of the Industrial Disputes Act 1947. It is seen that pursuant to the filing of the instant application and a reply has been filed by the respondent authority by the petitioner, who is the opposite party in the instant proceedings. In the said reply, it is mentioned that clause 11 of the appointment letter issued to the petitioner dated 10/8/2010 of the petition of the applicant, the age of superannuation have been mentioned at 58 years. It is further mentioned that in the evidence on affidavit filed by the applicant on 21/12/2022, his age was 56 years. And under such circumstances, as the applicant have already crossed 58 years, the question of benefit of Section 17B of the Industrial Disputes Act 1947 does not arise. This court have heard the learned counsels appearing on behalf of the parties and taking into account the appointment order dated 10/10/2020, which is annexure 1 to the affidavit in reply filed by the opposite party, and the evidence on affidavit which have been filed by the applicant before the Learned Labour Court, Assam, on 12 21/11/2022, wherein it is mentioned that the applicant is 56 years, the question of passing any direction for payment of the last drawn wages at present, cannot be granted. Accordingly, the instant application stands closed, is rejected. Be that as it may, taking into account that the applicant, who is the respondent in the accompanying writ petition, have already been, there is a direction for his reinstatement with back wages, and at present the issue pertaining to reinstatement does not arise, as the applicant have already crossed the age of superannuation. And the only issue is as to whether the applicant will be entitled to back wages, and early disposal of the accompanying writ petition is the call of the hour. In that view of the matter, this court fixes the accompanying writ petition for final disposal on 29/1/2026, on which date an attempt shall be made to dispose of the 29 আকৌ এইখনত এইটো হোৱাৰ পিছত ইখনত WPC number so and so. List the matter on in view of the order passed in IAC number 610/2025. List this matter on 29/1/2026 for final disposal. Records is it? Final disposal.
Item 2, by mistake, it's a
Oh, Bukazan Cement, what has happened? Argue. What case you have?
Union is, there is some grievances regarding the management and the government. They have finally, the appropriate government referred the industrial, referred their dispute to the industrial labor court Assam regarding the, regarding some point, 4 points. That is
Where is the award? Award.
what we got it, so we find at page number.
Whether the management of CCI Bukazan justified to deprive the members of Bukazan Cement for their legitimate promotion in time as per the rule in their seniority status, as compared to promoted workmen employees who given promotion by order dated so and so. whether the management of CCF Bukazan are justified by not giving promotion in time as per the rule or not issue notice under so and so to these employees who were either dead or retired from service without getting promotion. Not justified, then all eligible workmen should be promoted with retrospective effect and restore their seniority status. Who are the people?
They are the members of the workmen and they are working as a management secretary. And they all are now retired. They all are now retired.
And what is there to do?
Their benefits, the financial benefits, they did not, they are supposed to get their financial benefits. They are not.
You have not cross-examined the management witness on merits. Yeah?
The representation, the representative of the union, he was, at the time, he was in the medical and he
Well, that cannot be helped. I can't help you with that. Now what happened?
for that, he, with the medical problem, he not, appeared for the, tribunal and not able to share evidence.
So did you appear in 91, 92, 93 in the DPC?
No.
Why? You have a right to be promoted on the basis of seniority.
Sure.
Where is that rule?
But at that time, I was dismissed from the service at the time.
What?
Yes, I was, another case, petition is pending before your.
No. We are concerned as regards the promotion. We are not concerned with other things. It cannot be I, because you are a union. This is ventilating whose grievance? Whose grievance it is?
The member of this, they are here, trade union.
Where removal of discrimination in the respect of wage structure, promotion, earned leave, so and so of the management by adopting forming of groupism causing loss of seniority to concerned workmen since the year 1990. With a view to remove discrimination between the executive and the union and the workmen, the union demanded unified reinstatement. At present, there are 6 text sets of wage structures for the area. Whom do you represent? A record I say?
Button Cement Corporation employees. Button Cement Corporation employees. Their workers, my lord, please, is that the union belong to the, this particular union, they didn't get the promotion. So there are 3 unions for him. Bukazan Cement Corporation Workers Union, then Bukazan Cement Labor Union, and Bukazan Cement Corporation Employees Union. So their grievance is that but they never participated in the
DPC.
DPC, which was held in 91, 92, 90. So they are not considered by. And there is no specific case also that who has been deprived, who is retired, nothing is there. And it is not once, my lord, twice they got
Record I
rewarded.
say?
Lordship, para 8 may be seen, twice it happened, my lord. Para 6, para 6, page 42. May I read, my lord?
Then para 8 may be seen by what? Para 9.
You have not even reduced evidence.
So. It might be difficult to, I was, at that time, I was.
No, that cannot be a ground. We cannot raise something now. This is of 2009. I think
Para 40
you
may be
have
seen
to
by
give
what?
it a day. No. I can't help you. Heard Mr. This. I reinstated it, na, without causing any difference. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. J. Roy, the learned senior counsel assisted by so-and-so appears on behalf of the respondent numbers 3 to 6.
And where?
SR Bulwark for respondent number 2. Where is Mr. K. Gogoi? I should give him one disposal. Eh? Okay, Mr. K. Gogoi, I saw him today. Appears for respondent number 1. 1, 2, 3, 4, 5. So and so. The petitioner herein have challenged the award dated 30/5/2016 in reference case number 8/2009, whereby the learned labor court, Assam, have decided the reference against the petitioner it is seen from the materials on record that the government of Assam, Labor and Employment Department, by the notification number GLR.130/99/52 dated 13/7/2009, had referred the following questions to the learned labor court for adjudication. The said questions which were referred were herein under 1, 2, 3, 4 to page 38, 39 of this. The record further reveals that on behalf of the petitioner, written statement was filed on behalf of the petitioner as well as the respondent number 3 to 6, written statements were filed. Full stop. On behalf of the management, respondent number 3 to 6, who is the management, evidence was adduced, but the petitioner side did not adduce any evidence. The learned labor court, by the impugned award dated 30/5/2016, decided the questions so referred against the petitioner, and it is under such circumstances the present petition has been filed. The learned counsel appearing on behalf of the petitioner submitted that the learned labor court decided the said dispute, said proceedings not in the proper manner as envisaged under the Industrial Disputes Act 1947, and without further taking into account that the members of the petitioner union were being deprived of various service benefits, which includes the wage structure, promotion, earned leave, notice allowance, house building allowance, etc. Whereas other groups were given such benefits. This court, Mr. J. Roy, the learned senior counsel, appearing on behalf of the respondent number 326, submits that the respondent number 3, the respondent number 3 is a Government of India undertaking, isn't it?
Yes, sir.
Government of India undertaking. For the purpose of granting promotion, it holds DPC, departmental, what is the DPC?
Promotion. Departmental.
Promotion, DPC. And upon being satisfied, and those employees who have qualified in those DPCs have been granted promotion. The learned senior counsel further submitted that in the year 1992 and 93, all employees, workmen of the working under the respondent number 3 who were eligible were asked to appear in the DPC. And in pursuance to those DPC, those persons who qualified were granted promotion. The learned senior counsel submitted that these aspects were brought on record by the respondent number 3 to 6 in their written statement, as well as by adducing evidence. However, it will be seen that the respondents, that the workmen union did not cross-examine the witness on merits. Additionally, the workmen union also did not adduce any evidence as to what were the deprivations which had led to the dispute. This court, upon hearing the learned counsels appearing on behalf of the parties and also upon perusal of the impugn award, is of the opinion that as the petitioners herein have failed to show as to who are the employees who have been deprived, who are the members of its unions who have been deprived, and what is the deprivation which is being alleged before the learned labor court. There is no reason for this court for exercising its jurisdiction for issuance of a writ in the nature of certiorari in the facts of the instant case. Accordingly, this court, having not found any merit in the instant writ petition, the writ petition is dismissed. However, in the facts of the case, this court is not inclined to impose any costs.
I said 50, 50 to pay.
Where's my judgment? Oh, you gave it to me.
And what about here, my lord, the part of the document itself is wrong, my lord.
Why?
My lord, because that itself was issued in respect of only one item,
Huh?
only one item.
Where is the Suko's notice?
See, my lord,
311.
right, my lord, right.
Huh?
It's 75.
Page 65 or 67?
It's 75.
What is this? This is. Where is the Suko's notice?
It's 75.
Yes. For default.
In respect of only one item. I think
Where?
it's two orders.
Huh?
Whereas the final order, my lord, they have included 3 items.
Nowadays, that day, Manish Goswami, a counsel, was taking me through this blacklisting thing of yours. I think I fixed the matter on 2nd or something. 8th. No. I fixed it on 11th. I have added one more direction there. However, it's not a direction. I said that it shall not be a bar on the part of you. And also it shall not prejudice you. If you accept those drugs which you have already ordered prior to the termination, taking into account that these are essential goods. I said that depends on you, whether you do it or not. There's no direction. I give you the liberty. Yes, what is this?
It is in respect of one item, my lord.
Which item?
Item is-
It will be there in the schedule, na?
Two orders.
What item 1? There are 2 items.
Except of this injection.
0% delivery, 90% it has to be. Kindly see page 77.
That, right?
77.
Yes, I've seen that.
Then it is 100%.
No. Well, here, then, well, the proper is,
Ah,
they divide, well, they wanted to divide. But they can only, well, in that case only, in respect of that act. But the final order has been passed in respect of several orders, 3 items.
What?
By the manager, general manager,
Where is that?
98. Proper notice, only 2 items, 1 item, but here,
Where is the improver?
well, that page 101, this items are there, 7 orders. It got the respect of the close product. In fact, in the meantime, one of the managing director should yes, supply orders again after the shop. So losses scheme, it's supply orders. 6 orders. Yes, supply order. Yes, supply order. This 1991, 3 supply orders. And this item is also there, that way. I know whether that can happen.
Where is the Suko's dated?
Someone takes with that.
Where do I get the date?
They have 22, 11, 20.
Oh, 22/11. and they debar you on 11-3.
Yes. My lord,
You have an interim order.
1-3, my lord,
They've got an interim order.
no. What is? The lordship, my lord, shortly, 1-3 even supply order was issued again for the same item. Within 10 days again, my lord, this. Debarred order.
I was planning to have the instruction, as to whether my lord, the prior approach of the MD is not issued. Because if the MD were put out, like in a similar case, also will interpret the requirement of this. On the one of grounded, the MD has not taken the decision. So approval was there in that one. In the present case, no, it is. Demonstrated from the official office, the MD will report it. Thereafter, when the panel has issued the order. Because you approval of that.
Can it be done?
Yes,
How? Under what provision?
No, my lord,
No, under what provision? With the approval.
because it is the MD who take the decision. by the president.
So MD has to pass the order. You see, we are concerned out here, these are contractual obligations. So therefore, the contractual obligations are set by which you are to take a decision, the MD. It is not by way of a delegation is permissible under those acts. When you are taking a government decision, I would have understood if it is the health department. The health department, in view of the rules of executive business, they may delegate somebody. And this is permissible in view of section Article 166. But this is a company. How do you do that?
That is the one of the,
Problem arises there. That is my word. That is my decision.
like in the other case, here the approval was there.
Now, approval is there, but he has to pass the board order.
The argument that been fair, but
Even the so-called notice has been issued by the MD.
yes,
Then
happy for your work. So, my lord, there are 24 centers, my lord, the MD has delegated it to the general manager to decide the issue. Here, my lord, is the MD who has given the panel. There it was not there. On the record, it should be.
so therefore, you must be having a contemporaneous record of the MD's decision.
Yes, I put the. Document to internet is 47.
Page?
47, fourth page from the last one.
How do I know? Oh, 46.
Page, the bottom, page number.
Ah.
Note number 69,
Page?
page 47.
Ah,
Now, for the 69, 70, 71, 70, and 74. This will show when the MD has given them.
where's the MD's decision?
No, then, whatever,
No. Where's the MD's decision?
he has given the manual, so what is the manual after considering the reply and all.
Mr. Counsel. MD has to give, there has to be contemporaneous records. Then only, if you are saying that the MD has decided, but it is not written, that means there is no records.
Yes, but these are all manual, files, manual.
No, I'm asking you, so MD has to have a decision. Just for example, let us take the example of Vihan Kumar. I give you it's a very lucid example. You are required to submit the grounds of arrest. You must be knowing, I don't do much of criminal law, but what I can gather from that law. You are required to give your grounds of arrest. Now, in certain circumstances, it may not be possible to give a written ground of arrest. That has been considered in Vihan Kumar. But it says You have intimated him. The grounds of arrest needs a formulation in the contemporaneous records. Meaning that in the CD, there's a requirement of putting those, what are the grounds of arrest? This is in VR. That is the example I'm trying to draw out here. If you are saying that the MD has decided and asked him to only give that particular decision and intimate, it's just intimating, then where is the MD's decision?
But page, note number 68. Page 40,
Eight
40, the big page on the.
may be approved as proposed in.
The next prior page. Page
Ah.
40. Here, note 68, MD, so and so. No, this is the note, the recommendation, everything has been given, action required. Yes, prosecution say action required, determining the next step regarding the potential blacklisting so and so based on the outcome. The general manager put up this particular note, and 69 says may be approved, and even the chairman of the election, who is the commissioner and secretary of the health department, he has also given the vote.
So may be approved,
74.
may be approved as proposed in 67. 67, it is being proposed by general manager.
68,
67. Not 68, 67. Stop. Note 67.
yes. But he, ultimately, the decision is of the MD, without that, approval or consent, he cannot pass an order. The MD has said that yes. Not then, because if the MD will have to take a decision, he will, do all the paperwork, he will decide on the reply. His team will do that, and he will pick the final note. Then occupancy was vote number 74. And 75. 75 says very clearly, first time to the approval above from the commissioner authority, note number 70 and 71. The draft firm development. So this address to ensure the amount supply of the number of investors. Draft development is based on the draft number so is so subject for time and Seventy is also.
But tell me, the draft debarment notice is placed under draft number so and so. This is by the senior manager supply.
Yes.
Then general manager procurement. Where's the MD?
So MD, madam,
Where's the MD? MD has also not seen the draft here. You show me another thing which I'm here. They'll allow the repetition. The question is, should they allow in such a manner that the earlier order was limited? But should we allow more because of the fact that where is the penalty clause? How?
Yes.
Because the year you could not have done so.
103.
No. Where's the letter of intent?
Yes.
In fact, in that earlier case, no, Mr. Gogoi, that case which is there, which I was taking up, that was the name is Nestor. Nestor is yours? No.
No,
Oh, that case. That is Nestor. You have taken up, you have done everything, every one point to the other, it has been done properly.
so now, they're saying, yesterday I thought they said, now we are doing it. All, everything has been done by the.
You see, MD has to do it, and no, in fact, the manner in which in that case it was done, very properly it was done. Not in, you see, if every time you are issuing a fresh debarment notice, so in that case. But here, you issue on 22/11, then you keep on giving extension, and then one fine morning, you refer to the so cause notice and then finish it.
Then supply orders should be done. The orders.
No, that is a different issue. It might not, if the development was not there, what they have to supply? When development is there, will not be.
No, I'm not on that issue as to whether in the meantime some supply orders are being given. There might be many other things, like Cadillac supplies not only many other aspects, like various items are there, so it may be. Now, the question herein is this letter of intent gives another aspect, penalty clause, penalty 10% is, what happens when one item is there?
Based on trade.
35,
Product development.
35.
Huh?
Product development. Based on-
Base 35.
That is one item.
30?
35. L and M.
In a batch, in one batch or two batches of a particular item supplied by the firm failed the quality test. In a batch of theirs supplied, the firm failed the quality test. Where the supplies in the being for 3 or more items and debarred for minimum of 3 items. The firm shall be blacklisted and debarred from participating in any tender for any item issued by the TIF for 3 years from the date of injury. Forfeiture of years supply penalty so and so, penalty for delay. In case there is delay in delivery beyond the stipulated period as mentioned in the purchase order, there shall be a penal deduction of so and so subject to a maximum. Product delivery. In case of non-supply or incomplete supply of less than 90% of so and so. Now, firm debarment happens when there are 3 items.
What is, items is kind of important. That case, it will be the firm development.
But what you have done, you have gone for firm debarment without a notice for 3 items.
Yes. They make your hand for it. But one thing, the way, usually the work, medicines are supplied, these are free medicines which have to be supplied to them, post data of the.
No quarrel, no quarrel. Mr. Gogoi, I'm here. There is no quarrel with that, but the petitioner has to be here. But the fact that whatever may be the law is there, no?
That liberty may be given.
Now it is matter of supervisor, because hearing need to be given.
Hearing, that, I will, even Gurkha Singh is very clear. Focus is enough,
That is not something that judges can hear.
very clear.
No. In the earlier case, I gave a hearing. There is a reason why. Because otherwise, you will just put a name, change the name. No, we have to set aside in this case because it cannot be a case of firm debarment. One, because your so-called notice was only for one item.
One product.
One item. Secondly, it has not been done by the managing director. These are the two reasons. Thereupon, I leave it to you what you do.
But the hearing part may have played the part. Personal hearing, whether it will be necessary in a case of department or practice. One other thing.
I could see the results are there, so what the results are there.
No, I'm not saying about farm department and the hearing. I gave that hearing in that case. There's a reason why. Because otherwise, what will happen? You don't have, I allowed you to take a decision. But you did not take the decision, the managing director. Now, what will the managing director look into? So therefore, the hearing was given in that case. Here, I'm not going to say anything. I'm going to set aside this. Simple. This is not a case of remand.
Just like there are plenty of this.
Because Gurkha security, Mr. Kane showed his favorite judgment.
One on it. Page 118,
But subsequent judgments are there.
page 118, paragraph 20. Thus, there is no dispute about the requirement of serving SOCO service. We may also extend that once the SOCO service is given, an opportunity to reply to the SOCO service is reported. It is not even necessary to give a oral hearing. The High Court has rightly repudiated the appellant's attempt in finding foul with the interim order on his law. Then, madam, paragraph 22, madam, Lordship may kindly see, last paragraph, paragraph 22, last sub-paragraph. There, madam, two grounds have been given, madam, what should be there in the SOCO. Madam, in the last paragraph, may hasten to add that even if it is not specifically mentioned in the SOCO service, but it can clearly and safely be discerned from the reading thereof what would be sufficient, that would be sufficient to meet their requirement. Here we have mentioned both the clauses. One is farm department and product department. So it can be inferred then, my lord, what is our intention otherwise in the SOCO. Though, my lord, that initially when only two items have been mentioned in the SOCO. But
One item.
one item. But in the meantime, my lord, yes, what has been more than 3 items. That we have, in fact, in the.
But
Yeah,
you,
madam.
because of the 3 items, you gave the,
That's what they felt that is given. So we will see on that part.
Hello. okay, we'll dispose it of today itself. You'll get the order tomorrow.
Page minus 79.
But there is one recent judgment on that, on personal hearing. There is one judgment. Recent. What is it? Justice Vishwanathan's judgment? Yeah.
The earlier judgment is also there, Raghunath Thakur.
Yeah. Good.
And that was in
This,
pharmaceutical manner.
I can,
Then.
Eurasian, Putsha. Yes, what is that? Right. Not old judgment, new judgments, yeah.
One Raghunath Thakur, one Dapodi,
Rajesh Agarwal.
3 judgments of course.
Paragraph 60. In Raghunath, 2 bench of the health that seems Beckley intensive an order of declaration should issued only after following the principles of natural justice. To be restated. Where does it say it is required today?
98.4 Malo, theology is the. Also other case.
Such a department and the swans of the master range and the Guru are being understood. Oh, I remember. This case is now pending. I think they have dismissed it. A review was filed against this order by the State Bank of India. This is as regards the master circular, no? Where somebody made a fraud and all. No? It was before Justice Pardiwala and another. This was issued to the RBI. This matter is pending reviews. Anyways, no, don't worry. Why should I go into that? here?
Not before in this case.
No, that I would not go into that. I will set aside those. We are not going to go into all these unnecessary things. We set aside this. You take a decision what you feel like. I'll say that setting aside these decisions shall not bar the respondents to take such decision as per. And why do you make their so-called notice or extension notice so long? Make it short, precise. What is wrong with you? Such every notice may consider what is wrong with it. Every time we are putting the entire clause out there.
Here, my lord, the extension was issued after the focus.
Even in the extension again, you are putting that. And make it simple for courts also to look into it. Chalo, we'll dispose it up to date till we get the order. Chalo, dispose it. Pass the order. Yes, Mr. Chaudhary, what is your matter you are waiting for?
But there is no matter, but my understanding is for the finish time for the respondent.
Since that passed away, whatever in the stand up India scheme. Whether the applicability of the continuation of the stand up India scheme to a tender.
Oh, Stand Up India, ha.
I did some research about it.
Oh, there, he was, yes, where is the central government? There we get. See, at last central government has come up. That they saying something in the order made sense. There is no Stand Up India scheme. Everything has gone for a 6.
It's like as per this.
Better, I think, we should not discuss about your case.
Yes. Right.
If I say anything in your case, it will have far-reaching consequences in the other case.
Possibly, those days, who are the petitioners will not stand up, SUIs, yes.
Let me think about it. Give me a recourse after you have made such forceful submission on the last date on 24/11.
Right, I can affiliate just clarifying that.
No, because there is something about, anyway, Milord, since the authority has said that, you must have my part. But then, Milord, going by this scheme, you would also kindly take.
No,
all
Mr. Chaudhary, there's no problem with other thing.
Yes,
You give me only one way. How I tackle you out, give me that from this problem which you have created by coming here. I don't need anything else. The rest I will take care of.
my, in that case, my submission would be, when they say that the Stand Up India scheme was closed on 31st of March, possibly refer to that as central, yesterday. Now, yesterday, CGS.
Can I submit? Can I take it yours? Okay. I'll just think about it. I'll dispose it on another day. Just think about it. Can I take it as your submission? That the petitioners have not challenged any tender process insofar as qua you.
Number one.
So under such circumstances, the declaration so made
Could be confined to.
cannot be given for everybody, shall only be confined to the present tender. That should be your submission. I think
That is one, and number two, perhaps, Miller, this central government. A credit guarantee scheme, that is a standalone. That is a standalone scheme. There are other schemes also. That's what I was trying to say. So
that is what
losses will be
now
confined to
stand up
the
India scheme.
Central guarantee scheme.
Understood.
Is-
You on the last occasion submitted, there are three,
Oh,
as per you,
yes,
as
yes.
per your knowledge. One is the Central Guarantee Scheme, CGA. One is the woman, what are the schemes?
Belong
Three.
the CGTMS.
Standing MSME category,
Yes,
women scheme,
yes,
startup category.
yes,
These are all various components.
yes. So.
That in respect to Stand Up
petitioners
India
got
scheme, startup
CGS.
category, the scheme have been discontinued. But on not in respect to Stand Up India scheme, MSME category or women.
Yes,
So that is here.
yes.
If I may just clarify. Stand up India scheme is only for SCs, STs, and there is no. MSMEs are not a category of eligible for us under the stand up India scheme. However, for MSMEs, there is a scheme called the Credit Guarantee Fund Scheme for Micro and Small Enterprises, which they are referring. That scheme is still valid.
Yes.
If at all they are eligible under that scheme in the Manipur tender process, that we have not challenged here.
That's all.
We should not say anything today. I think what I said in your submission will be better.
Yes. That will be okay.
And then deal with this petition.
Something required here in this tender process, at least the work order which I am challenging, is that the person who has.
I understand. I
Yes.
remember. Once a matter is moved, I remember. These people got the benefit of Bank of India. Bank of India, till now, Mr. Borwa, they have not replied. But they still continue that they are going to support them.
Well, other banks.
Have already given
banks
there.
stating that they are not extending the credit facility because the SIS has been discounted. Therefore, those bidders who have been replied with, their bids have been invalidated, their LOAs have been cancelled. We are only awaiting a reply from the Bank of India. If it comes with a negative, we will be obliged to cancel in any case. If the Bank of
Who is
India.
paying for response number 7?
6 and 7, the Bank of India, we are trying to reply today.
What is your stand? Your reply is important. What is your stand?
I was the certificate issued, was, the Stand Up India scheme was discontinued, the scheme was discontinued.
Then why you are not replying to them? Matter would have been solved. And then they come before the court, causing everybody tension. We'll have it again on Tuesday
Yes.
to finish it off. Only that small issue out there. You have filed your affidavit today. Okay. It has been submitted that an affidavit, it has come on record.
It hasn't come.
Miss K. Pukan, appearing on behalf of the central government, respondent number 9. Respondent number 9 have placed before this court an email dated 1/12/2025 issued by the Stand Up India issued by the SUI Stand Up India core team to Mr. Ranjit Kumar Dev Chaudhary, the Deputy Solicitor General of India. The said instruction, said email is kept on record and marked with the letter X. This court have also taken note of the affidavit filed by the respondent number 10 and 11. Your bank? 6 and 7. Who is 10 and 11?
We are getting.
Filed by the respondent number 10 and 11. Your affidavit has not come on, no?
I filed a reply.
Record.
Okay. Mr. So and so appearing on behalf of the Bank of Respond number 5, 6 and 7 submits that an affidavit has been filed today. List this matter on 9/12/2025. Gustav. The registry shall bring on record the said affidavit filed by the respondent number 6 and 7.
Calculating must be listening for orders. So perhaps a lecture will be required from your lordship that all parties are.
At on so and so at the admission column.
That is we will also going to file it. So now five.
Who is 5?
National Credit Guarantee Trust Transfer.
You have filed.
No.
File your affidavit by Tuesday.
Yeah.
A short, because you are the main person. File it by Monday. Okay. Mr. So and so appears for the respondent. All of your names clearly give, but Mr. So and so who appears for the respondent number 5 submits that the affidavit of the said of the respondent number 5 would be filed up on Monday. Anything more? The hearings. More hearings. What is this hearing? Yes, Mr. You along with your electricity problems. Electricity.
Number 11, we are agreed by the manner in which an assessment bill has been calculated by TDC.
You filed appeal under 127
Yes.
and the appeal was dismissed. Dismissed.
Not discussed, partly allowed.
So against that you are here.
Yeah.
Is a stay.
There is,
Whole matter.
yes, 2017 man.
No dates. Very tight up.
Two is on a very narrow grounds.
What is that?
That they are saying on the facts, whether there has been tampering or not, they are not raising. They have not raised any grievance regarding the facts, whether the tampering took place or not. Only as regards the formula which was applied while calculating the case system. I think if I understand
What do you say about the form?
my submission is correctly. The formula under 126 and then modified under the rules supply code, that has been applied here.
Why do they say about the formula? Because of the MDA meter.
No, not the Indian meter. Their submission is that since they had tampered the electricity, but during that period, since they were otherwise paying electricity charges, so that figure your lordship should not be taken into account because they were paying electricity charges during that period.
How is it possible?
Exactly, our case is that since the
Only
meter
that
is-
amount, whatever has been paid will only be deducted from the final year.
And once it's tampered, we cannot determine the actual consumption of the meter. That is our,
For the last 12 months, it has to be taken
that we have done.
from the date of inspection.
Yes.
I'm not on that. My case is that while calculating the assessment bill, they have taken into account the sanction load. My case is that connected load should be taken, not the sanctioned load. Because in a tea estate, the number of machines are there, so the connected load is very high. But all the machines are not used simultaneously. Only the contract demand, as is reflected in the bill. The contract demand should be taken into consideration while calculating the assessment, not the connected.
Contract demand means?
Say for instance, our connected load is 100 kilowatts. Considering all the machines we have. We never used those, that 100 kilowatt at one go. So our contract demand will be 60 kilowatts. So at the most, we will use 60 kilowatts at one. And that will be seasonal and off season. In off season, electricity consumption is very less. So my case is that while calculating the assessment bill, instead of the connected load, they ought to have taken the contract demand into consideration. And
But contract demand as on?
contract demand is
sanctioned by them. And it is reflected in the bill. That is what I have said so in my.
No, no, no,
affidavit.
no. See, the connected load keeps on changing. The connected load at one point, you say. You see, there are many various loads. One is a sanction. Sanction may be,
Sorry, sanction.
so you say about the sanction.
Yeah.
That is why you are saying the other way around.
Yeah.
I'm therefore finding it very delicate. But the fact remains, it is the connected load which keeps on changing.
Yeah.
But the connected load is the various appliance.
Various appliance.
Now, the fact remains that if from the appliance, it is more than the sanction load. Is it more than the sanction load in view of the connected load?
Yes, connected load will be more.
Just for example, a house may have 15 kilowatts. But connected load means with all the ACs connected but not used.
Yeah.
It may go more than that.
Yeah.
Yes. But as in this agreement with your lordship, both connected load and contract demand is defined. So what is basically paying for is, since it's a tea industry, the lordship would recollect for tea and coffee industries. There's a difference between,
December, January, February.
yes, your lordship. So basically,
Seasonal.
what he,
Seasonally.
Seasonal, but 3 months.
what
December, January, February.
basically the pair of the share is that since for say for these 6 months, I will be using 70%. And maybe for the next 6 months of the year, I'll be using it slightly more. So it should be calculated that the amount that I'm going to use, actually use the electricity. Our case is that once you are caught tampering with the meter, and there is a formula laid down under the act, at what rate, what level.
Regulation.
Under the act also, under 126, it says that it has to calculate at twice the time.
It doesn't say
It
about.
doesn't say about sanction load or connection. And the regulations have been framed pursuant to
No,
that.
no, unless the regulations are put to challenge.
Yes, unless the regulations are put to challenge.
So regulation categorically says what? I can regulation content.
At that point, 2007 were in place.
We are concerned about 7.
Yes, this is the new one.
7.2.
This will be regulation 5.8.4.4. The page 122.
Page
122 at the bottom of the page.
Ah, 5.4. You
5.8.
unmetered use of the interference with the metering system.
5.8.4.4. Unmetered use of.
Where a consumer indulges in theft of electricity. This is not a theft of theft.
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 They say that the meter has been tampered. So
Now, is it unauthorized or theft?
it's an unauthorized.
Foreign circuits were found inside.
Okay. The officer authorized in that behalf may, without prejudice to its other right, will assess the quantum of electricity loss on the basis of assessed consumption of detected category as per table 6.2.1 and connected load for a period of 6 months prior to the date of detection, and will be billed at the rate of 1.5 times of the existing tariff.
There is an amendment to this option.
Now, in one case, in Kachara law, I passed the judgment,
Yes.
wherein there was a challenge being made. I think who was challenging? Other
So
side.
Das was,
Huh?
Mr. Das was.
Oh, yes, whoever.
Mr. Das.
So there the issue involved is that, you see, look here, it is a case of theft. It is not a theft has to be proved. So till it is not done, it has to be done as per the unauthorized use of electricity. Then I say that unauthorized will also include theft.
Okay.
And if at a later stage it is found, but if you have you filed the case?
Yes.
Because you see the judgment of 2003 or 13 of the judgment which I referred to in my judgment.
Yes.
It categorically says that if the matter goes to the special tribunal under 135, 135, the special tribunal can adjudge. Now, if this 135, it goes, and then whatever it is, if it is found that there is no theft, the theft requires a mens rea.
Yeah, that requires.
A foreign circuit is another aspect of the matter, but the theft requires a mens rea. So mens rea, if it is so, it has to be proved against you. Then only that assessment, which is like the land grabbing case. First criminal, then the civil. Here, in that case, it is first the civil, then the criminal. So here you have to first find out whether there is theft. Once it is theft, then you can go and apply under here. Otherwise, they will do it under 135(5). So that final thing will be bounded on this. But in the meantime, you have the power to assess as per theft or whatever it may be. Isn't that, am I right?
Yes. Best judgment assessment will be.
Huh?
Best judgment assessment will be. And the
Ah.
126(1).
126.
So my case is that instead of the sanction load, the contract demand ought to be taken into consideration. Because as per the amended,
No, that cannot be used.
because the lordship will kindly consider.
Use
As
of
per the
electricity for
amended
any other
regulations
person other
also.
than for which the supply is connected. No.
There is an amendment to this, Your Lordship.
Hmm.
2007, the Electricity Act was amended.
Mm.
So this 1.5 times in 6 months is now 12 months and twice. At 5.8.4.4, the Lordship will see it's 1.5 times the existing tariff for 6 months. When this supply code has been amended, I have given a copy of the amendment. to Lordship. So it has now become twice and for 12 months in terms of the electricity Act after 2007.
So it has to be as per this
That's what this.
5.8.4.1. You were there in that matter.
I was.
Lordship, my contention before lordship, is, while collecting load security, they are not taking into account the connected load. They are taking into account the contract demand. Even while assessing load security, as per the amended regulation. So while preparing assessment bill, they should also take into account the contract demand.
For that, you need to go before the division bench to challenge this clause 5.8.41. I can't do anything. This is the law. So, bad case. There's no time. Anyways. In fact, Tuesdays and Thursdays are better for me. Otherwise, all other days I can only hear non-payment of dues. Chalo. When do we, this won't take much time, but I don't have time. See? Court, I have 9 cases. Then finish it off. Huh? 19 is the last day. They won't like the year to end with a dismissal. Duke. If he was allowing him, he would have. Let's try a luck on 4th. Taking into account the matter has been heard, so I'll list this matter at 2 p.m. on 4th, 2025. Ekon thorai dibo, huh? Already, is already. Take it up. Liberty given to the parties to mention the matter for upgrading. There are people do that also. Do that.